Your Lordship may mention one matter, Your Lordship, was is to make this matter go out of this with liberty to mention. This is that matter regarding 713 which was pending before the Supreme Court. Now the Supreme Court has delivered judgment on 13th of August. I'm praying for listing of the matter.
Mention on Wednesday.
Extreme urgency in my matter is that 21st of August is the date fixed for delivery of position. The matter you also may recall the correction of degree and subsequently I moved on civil division and application when a question of the arrows. I relied upon 1984 Calcutta. Then the court has that the tenant has relied upon. I found all these things, but if the matter was acted on my prayer without fixing any reasonable date, the opposite party by way of put up deep on the date from November to August 21st. Unless I am mentioning with notice to opposite party. Unless the matter is
Your Lordship, in this matter, Your Lordship, on Thursday, my learned seniors already mentioned, and on Thursday, that is not a mention in the Your Lordship says. And Your Lordship says that the mention will be taken to Your Lordship. This is section 20. Yes, this is
Urgency.
urgency is section 24 application, Your Lordship.
Section 24 transfer.
Yes.
Transfer, I do not have determination.
I know that, but Justice Dinesh Kumar Sharma's partial determination has been there in this case.
Today,
Yes.
আজকে এসছে? I do not, it was till 14th.
Till 14.
Yes.
May I kindly be
I'm
permitted to
sorry.
mention with regard to item number 59 of today's list, my lord, next date fixed on 20th of August before the landed court below. My lord, in this matter, I am for the opposite party. My lord, although there is no order of stay, the petitioner, my lord, took adjournment by showing the,
You
my lord,
proceed,
kindly,
there is no bar.
my lord, kindly consider, my lord, took several adjournment, my lord,
Maybe
is showing this
you
pendency.
cite the provision of law.
My lord,
You cite the provision of
my
law.
lord, kindly, my lord, here, my lord.
Yes, call the
My-
list. Yes.
Number 1.
Item number 1, Your Lordship, Mr. Shaunak Bhattacharya is appearing on behalf of the petitioner.
Since I am not inclined to take up
But I appear for the opposite party. This is appearing at my instance. My lord had passed an order on 4th of August, but that's at page 8.
But my senior in this matter, my lord, he has not yet come to court, my lord. Just 10 minutes or 15 minutes pass over, my lord.
page 8.
But what had happened, my lord?
Yes.
There was a
Oh,
caveat.
caveat
Yes,
is the-
the caveat, my lord. I'll show your lordship.
10-15 minutes pass over, my lord.
My lord, the caveat, my lord, kindly turns to page 18. That's the first caveat, my lord, which was filed on 11th of September.
Yes, yes.
And the-
Caveat you have not thought, sir.
But this order has to be
Just
recalled, my
pass over,
lord. In
my
Yes, yes.
my lordship.
This matter has Call the next matter.
Item number 3.
My lord, for the petitioner, my lord, this is that matter where the, my lord, plaintiff was given cost of 5,000 rupees and upon filing and recalling application, another 1,000 rupees was imposed upon the plaintiff. This was the affidavit of service, I have served upon the opposite party, the advocate.
It should have been served upon the party, not upon me. I was the advocate in the
But
trial
the
court.
speed post was not working, that is why I served directly upon the advocate on 8th of August.
Yes, now
You have not, I have not instructed him.
you have not been instructed.
Madam.
I have served
Can you take instructions? I am keeping it tomorrow.
No, madam, my client, I fell hanging up. He's out of Calcutta for a week. That's whole difficulty. Madam.
The difficulty is the lower court matter is on
Let them
21st
send it,
August. 21st August.
settlement.
Service by post was not done. I am candidly speaking about the speed
Why you
post.
have not served by speed
But the
post?
speed post was not working. But there was no tracking report. It started only on Wednesday last week.
Already you served.
And I can serve now.
The
But the only one thing on 21st August, the matter is before the lower court. But may I be pleased to proceed with my order 39 rule 7 application?
the learned advocate appearing
Appearing on behalf of the
But I appear for the
opposite party.
petitioner, it's for extension, third time. my lord.
Yes, Ms. Bhattacharya, extension of interim order.
Here, my lord, perhaps it would be better to dispose of because, my lord, in the rules, there is an appeal board. And against the founder body order, that appeal board should have been approached. In the service rule that is there in rule 24. But
This order is continuing from long.
yes,
Well, it's
Then
September
the-
2024.
None of the occasions you have mentioned this. I'm keeping it, I'm extending this interim order, I'm
allow me, my lord, because it may be, my lord, disposed of. Or, my lord, let it be a date fixed, my lord, because I am suffering from some ailments. So, my lord, let a date be fixed. I will come and I will place short affidavit only.
you will affidavit to the civil division application.
That is review application. But I think, my lord,
For what? Civil division application, affidavit for what?
for my lord.
Bhattacharya, this is the
Nothing like this.
civil division application, affidavits are called for, Ms. Bhattacharya.
Let it be disposed of fixing any day, very short, because I will be praying, my lord, to dispose of, allowing me to file the appropriate appeal before the final appeal board.
What do you say to that?
Well, in accordance with law,
But within 60 days, I have to, but my lord, for the my legal advice, my lord, I have filed the suit. So, my lord, that is, my lord, I am praying that liberty only, that the delay may be condoned by the appeal body in accordance with law.
Appeal body, you have to apply before the appellate body.
Yes.
That cannot be condoned from here.
No, my lord,
No.
that may not be
So you
condoned.
will withdraw the suit.
Will then, if it
So you will withdraw the suit.
obviously,
So I give you that liberty to apply before the learned trial judge for withdrawal of the suit.
I think that.
for taking appropriate steps, my lord.
For taking appropriate steps. And which order was under challenge?
Well, look, this was passed on an application under Order 7, Rule 11. My lord, it was not only the point of alternative remedy, but, my lord, the maintainability of a suit. My lord, a contract of personal service, lordship knows, cannot be specifically enforced. That is what they were seeking.
No, then, my lord, if another point is approached, my lord, then, my lord,
How can I jettison any point, my lord? There were 2 points there. I'm pointing out what's on record.
No, there are two things. Their application under Order 7, Rule 11 has been rejected, against which they have come up here. Now you also admit that there is an appeal body, so the suit
is that.
itself was not maintainable. So I'm not rejecting the plaint here and now.
Yes.
So but unless you file, withdraw, I give you liberty. I'm keeping this matter pending.
Yes, yes.
So I'm
If
giving
the
you
liberty
liberty.
to take appropriate steps.
Then we
do
will
that.
mention it here,
Yes,
madam.
After that, please.
yes, yes.
Uh, and what was the interim order?
Well, the interim order was stay of the proceedings, my lord.
Stay of the proceedings. But
Kindly
I
see
only
audit-
allow them to file and the learned trial judge to take up that application only. That
Only.
I
Yes.
think
Okay.
this application under
Milord, in new motion, Milord, this petitioner made an application that his father and paternal uncle.
please use the microphone.
Okay.
Please use the microphone.
Oh,
Yes.
that father of the petitioner and paternal uncle are mentally unsound and disordered. And actually, the opposite party has obtained a deed of a gift from the person of unsound mind. And this petitioner prayed for medical examination and also for appearance that was rejected, against which the present revision is prepared.
Yes. What is the document you have to show that they are mentally ill?
Milord, they are confined by the opposite parties. Then how can I, until they are produced before this honorable court or before any court of law?
Then what is
That's
the
why it's a
basis?
very
What is-
serious case.
Then you do not know whether they are mentally sound or not.
That is to
How
be.
do you say that?
How can I examine Milord when they are under the custody of opposite party?
Where is the order dated 30th of July 2024?
Yes.
38 days. 38 July, 38 July. Then she,
And then,
P5, 38 July.
yes.
P5, 48.
And it's a P5, 48.
Page
Page 48.
Page 48.
48. Yes.
Now, my lord, actually it's very serious thing that the court has not examined at all.
Court has examined those persons.
No, my lord,
On 30th of July.
kindly bear me. When they are mentally disordered or unsound, how they can answer to the court?
They have answered to the court.
But
You have not challenged that order of 30th of July.
actually, it is not expected that they will answer. When they are mentally,
That was in your presence. They answered in your presence.
no, we were not allowed to.
No. You were present there.
But was not allowed to say anything.
Show me that you have stated in that application that you are present, but
That we have stated in our application. my lord.
show me that you are not allowed to say anything on that day.
Yes,
On
recalling,
30th of July.
recalling. Yes, my lord, we have stated that.
Yes, show me.
Yes. Yes.
49.
My lord, it's 49.
Yes.
We have made
Which paragraph you have stated that in the front of you they submitted this and you have objected to those?
Yes.
Show me which paragraph says so.
Paragraph 5, my lord, at page 50.
Paragraph 5?
At page 50 of the petition.
Yes.
That in fact those two persons were under threat and coercion, including physical assault, tortured. What to be said in court like a parrot? What to be said in court like a parrot? Cannot. They cannot say anything what has not been taught.
You are present on that. They did
Those
not object
persons
to
are
that.
in a place where plaintiff and their men shall have no entrance, and keeping them in a home controlled by central government, and after keeping them for a reasonable time, they ought to be brought to the court and placing them on dock of this learned court with the effective involvement of both the parties. So that helpless, mentally disordered person may be rescued from the hands of till they are under custody of this person.
What is the stage of the suit? What is the stage of the suit?
Stage এখন কোন stage আছে? Only a preliminary stage. Therefore, it is very. They are till since 8 years, my lord, under custody of the opposite party.
This application under
I'm appealing for the petitioner.
Six. Any caveat is there?
No,
caveat.
six no. Six mile Togori Vishwas.
Seven,
versus-
seven.
I am appearing for the petition. Six no.
Sorry, sorry.
Yes.
My lord, the order, my lord, the passed by this trial court, my lord, I have take a time before the trial court for give the evidence. I have been refused. And your lordship passed an order expedite the disposal of the proceeding. So PW1 has been examined at the 12:30. I prayed for time, but they have not given any chance. PW1
Rightly.
is closed. And,
Rightly.
and thereafter, my lord, the 2 days,
Adjournment is not a matter of right.
my lord, I am not
We
ready,
go
my
to
lord.
the court and pray for adjournment, that will be allowed.
12:30, they have been given evidence in chief, tendered. Thereafter, within 15 minutes, trial court directed to give the cross-examination. I have refused to take the cross-examination on that ground that I prayed for time. Yeah, I am not ready.
Not on that date, sir.
Last
30th of July,
30th
the evidence of plaintiff witness was closed. You did not cross-examine. The date was fixed on the next date, not on that date.
No, by that, they kindly see last portion. Last in the above circumstances, considering the
Which order?
29 July 2025, I mean, 3 orders I have been challenged.
29th of July. Yes.
The last portion, kindly come to the last portion. That is,
Yes.
the defendant, the respondent is hereby given opportunity to cross-examine the PW1.
Yes.
He refused to cross-examine the witness as a
Yes,
cross-examination.
why did you refuse to cross-examine?
My lord, within 15 minutes, 45 minutes before the recess, they have given chance. But I have been refused to give, I am not ready. This
Why?
is
You are present, sir, at the time of examination in chief. You have asked to cross-examine, you refused. Rightly, it was rejected.
my lord, I have been prayed for
Thereafter
them to come ready, man. They are the next 2 dates, my lord. I did not
On
appear.
the next date was fixed for examination of PW2. You also refused to
No,
close.
I did not come only ground of my lord the daughter's examination. Last 2 dates, that is the 30th July 2025 and 31st
Whose
July.
daughter's
My daughter's examination, I did not come before the trial.
the petitioner's the
Petitioner, wife petitioner.
wife will cross-examine.
Wife is cross-examined. But yes, my lord, the mother-in-law was examined. But I did not appear. So learned trial court observed that you 2 dates he did not appear. So
What happened on 20th of August?
20th
of August.
But date fixed for the argument.
Rightly.
Kindly, when I allow me to
Participate in the argument, then
participate, there is no, I have no.
how much cost you want to deposit? Please first deposit. I will allow you to serve. If I allow you to contest, that will be given to them. Yes, you volunteer how much of cost.
My
If
lord,
you are reasonable, then I will decide whether to allow you to serve or not.
my client is willing to pay.
How much?
2,000.
2,000.
2,000, my lord.
is
My lord, he's a wife, he's not upon the maintenance matter, my lord, the regarding, my lord, kindly appreciate. Otherwise, my lord, even they kindly see the section 24
some
application.
figures on the right hand side after which you have quoted.
Sir,
Any figure which you want
right,
on the right hand side with the figure which you have quoted.
my lord,
Any figure, that choice is left with you.
no, in this matter, my lord, I appreciate the section 24 application has not been decided. My main matters has been decided. We are not getting it. Only one for application on the miscase 21 has been registered. It has not been decided. They have to, my lord, learn a trial court observed, but both the application are together. So, my lord, that this application has
Section 24 pending.
pending.
Show me the order sheet that section 24 is pending.
There is up to date orders I have been
Up
annexed.
to date orders, none of the orders speaks of section 24.
Kindly see.
None of the orders speaks of section 24.
I tell you, lordship.
Show me which order. Have you stated that in the application, civil division application?
You will use I tell you, lords.
Section 24 is for transfer.
No, section is the Barasat code. This is the main matter. The section. That is Hindu Marriage Act. I am telling you, lordship.
Show me where have you stated in the civil division application with regard to the
My come to
maintenance.
page 7. Page 5, paragraph 7, that your petitioner states that your petitioner filed 2 petitions. One is section 24 of the Hindu Marriage Act 1955, being this case number 21 of 2022. Another petition for stay of further proceeding matters till the disposal of 2022. Both the petition has not been heard, though the learned trial judge goes for fixing the original suit for evidence.
Where is your application under section 24? Show me.
24.
Show me any order fixing a date for the
Evidence.
miscellaneous case. This order from 2019, none of the
2019.
order speaks of the miscellaneous case under section 24. You sat tight over that, sir.
Kindly come to page, kindly come to ordering portion, inner page, order number 21, 3rd March 2024.
Did you serve that copy of the application?
I have been in when a page below my lord, I have been.
Show me that you have served.
Well, this application shows that he has been.
Copy is not served
Copy
due to the non-availability of the learned advocate for the petitioner. You did not serve even that copy.
Section 24 application.
Yes. Order number 21, which you have pointed out right now.
Transfer and the court is lying on vacant resolution and the.
Copies are not served upon the petitioner due to non-availability of the advocate for the petitioner.
Hearing of the interlocutory petition, another petition praying for stay of the miscase now non-average of.
Then you have paid for transfer of the.
That is my lord the pending before the trial court.
All means to delay the matrimonial suit.
My lord, the only ground is my lord section 21 has not been decided. The section 21.
You have not even served the copy of the application.
Then my lord, the
nothing remains to be decided. You have, if you are not served, it's not necessary that it should be decided.
I'll give a chance to my lord the hearing of this my lord section 21 back first.
Which court?
My lord the Bonga, additional district judge second court Bonga, North 24 Pargana.
The learned advocate appearing for the petitioner submit Yes, Mr. Sheikh.
Caveator in a probate proceeding. Right? But the peculiar system has emerged. My lord. Probate application, I filed caveat, only caveator. Matter became contentious. Then, my lord, as we know,
He is the propounder.
he is the propounder. Now, the probate application is to be treated as the plaint and it will be transferred to the district judge. And it will proceed on the premise of the plaint being the probate application. And my objection as the written statement. This is the procedure, my lord. Now, here, my lord, once I filed a caveat, it became contentious. They filed practically a new plaint, impleading all heirs, even those who have given consent, as defendant, whereas I should be the only defendant as the caveator.
How are you affected, Mr.
No,
Sen? If
I'll
the
tell you
others
now,
come because maybe some again now.
Something different has happened. Now, my lord, what happened? I filed an application saying that this new OS which he has filed, that should be treated as inconsequential, because contentious is what the original probate application. Now, kindly come to that order at page 87.
By which it became contentious.
No, my application was disposed of, and the learned court held that yes, my lord, the kindly come to page 87.
87.
Order number 50. First application has been filed by defendant on 2nd May, wherein it has.
This is your caveat. First application. What is the application? Oh, the petitioner shall be the plaintiff.
This is for treating it as contentious.
Petitioner shall be treated as the plaintiff.
Petitioner means the petitioner in the probate application.
Yes. When the application for grant of probate
But the petitioner shall not be permitted to file a fresh plaint.
Yes.
In the present suit, plaintiff has filed a fresh plaint before the learned district judge after application for probate and contentious, which is not permitted under section 295. Defendant has prayed for declared plaint as inconsequential. Learned advocate for the plaintiff.
That was your application.
Yes, my application. Oppose the instant application. Submitted instant application is not maintained by affidavit is not in proper form. Relied on such and such. Considered. Section 295 uses the phrase as nearly as may be, which indicates that the proceeding shall not take the exact shape of a suit, and legislature did not intend it to be. In fact, wanted there should be a difference between regular suit and as nearly as may be a regular suit, and as nearly as in the decision. The Honorable Court was pleased to hold provisional retain its initial
shall
form.
not take into account the fresh plaint.
Yes.
But continue with the application for grant
Absolutely.
of probate.
This I was perfectly okay with this order.
Yes.
Now, my lord, if your lordship sees the entire proceeding, despite this order, was being carried on the basis of the new plaint which was being filed. I'll show your lordship.
Then what did you do?
Then I filed this present application, saying that this plaint should be dismissed.
Subsequent plaint.
Yes, the subsequent, because that is already the order.
Yes.
Already the order at page 87.
Now, what did the learned trial judge say?
Learned trial judge felt that I am trying to challenge this order itself. I am not. But kindly see the order once. Order 39.
Show me your application after this.
Yes. Application is 89.
You are the third defendant.
Yes, sir. I should be the only defendant.
So third defendant means after impleading all.
Yes.
So this is the new plaint.
This is the new plaint. I should be the only defendant, my lord. Now real
number has been changed. No, it remains.
Yes. Suit number has also been changed. It has become OS2.
No, OS2 was the earlier one also.
My lord, the earlier one was, I'll show you lordship.
No, after it becomes contentious, the number will change.
Yes.
Because initially was.
It becomes only TS.
No. Or OS somewhere else.
Even the High Court, it becomes TS, testamentary suit. There it becomes OS. I am not on the number, but But what we know is, my lord, the entire probate application as it is filed is treated as the plaint. I cannot file a fresh plaint like this, my lord. The entire proceeding has become defective. Kindly see the earlier original probate application is at page 59. Act
Mr. Sen, only one thing. Because you wanted dismissal of OS. Dismissal cannot have been. You can say that that the second plaint
should not be treated.
Should not have been treated or should not have been
But
proceeded.
that was my first application where I said that the second plaint should be treated as inconsequential.
Yes.
Court practically allowed that, but thereafter court proceeded on the basis of the second plaint. That is why I said this cannot be done.
Maybe the prayer created the confusion.
Maybe, but your lordship will now correct the system which is going on. It cannot go on. This is not the way the testamentary proceeding is continued. Your lordship will clarify that as I am the only caveator, no one has a right to participate in the proceeding. They cannot even come and support the plaintiff. It is now only the plaintiff's case. Sole plaintiff. It cannot be they are impleaded as defendants. They will come and support the plaintiff.
But, Mr. Sen, the findings are in your favor. Please kindly come to the impugned order.
No, but even
findings, because the application, you are responsible for that. The prayers have not been happily couched. For that application, because you wanted the suit to be dismissed. Suit cannot be dismissed.
But I am saying this.
That is why I am asking you what are the numbers of both these proceedings.
Different. Act 39.
No, after Act 39, has to be some number when it has been treated as a contentious cause. It cannot be the previous.
39.
Yes. So it has to be a regular number. What was the regular number after it was treated as? Please show me the regular number after the order dated 19th of January 2023.
So what happened after it became contentious?
Yes.
It is returned for presentation before the district judge.
Yes.
Here they took it back.
Yes.
And while filing it before the district judge, this new plaint was filed. That is the main problem. They did not take it back to refile it again. The proceeding is defective right from the beginning. Your lordship will just.
So there are no two plaints there. I was under the impression there are two plaints.
No, it is not. Kindly just compare page 59, which is Act 15, Act 30.
You have annexed, Mr. Sen, both the plaints.
Yes.
Or the other
Act
way around.
39.
The application.
Yes.
And the subsequent plaint.
Yes.
Where is the original application?
Page 59.
69.
59.
Yes.
Kindly see. Sarita Bagaria is the propounder. Page 60.
Savitri Devi Bhotika is the
deceased.
So this is the original application.
Yes.
Act 39.
Yes. And now kindly come to the plaint which they have filed. Page 50.
Page
50.
This is the subsequent one. After taking it back.
After taking it back and refiling it.
So that is original suit number 10.
It's now 2.
It's original suit number 10.
Renumbered.
Yes, I find it, my lord. Original suit number 10.
10.
Yes.
So, Mr. Sen, is this a different plaint from this page 59?
Yes.
Page 50 is different.
Yes. Kindly have a look at it. There is so many defendants. All of them have filed consent except my client defendant number 3. So it is right at the inception it is defective. That is why my prayer that you cannot carry on with this plaint. Now kindly see page 51.
Any change in the substance, Mr. Sen,
I
apart from those additions of some other defendants?
I'll show you, lordship. Just one second. Paragraph 2, paragraph 3, paragraph 4
changed.
This kindly see Savitri Devi in absolute healthy state of body and mind, every consequence. These are new pleadings.
Yes, how can you do this?
These are new pleadings. This has to be
How
proved.
can you can only take it back and refile that once it has become contentious. How can you
I'll
file a new plaint?
tell you. There is an order which is shown to your lordship at page 87, which
Page-
records 87.
Yes,
This order is of November 2023.
yes.
Now, the only object is to delay the probate proceeding.
Why not?
I'll tell you why.
So can you?
Procedure has to be kept into. I have taken it back. The district delegate, it was filed with district delegate initially. Then district delegate returned it to me under 288. I have to file it once again with district judge. That's the procedure. When I file before the district judge, the LCR or the district delegate's LCR has been tagged. Now today, page 87, the order records that my new pleadings will not be looked into. Only the original pleadings will be looked into. I'm happy, he is happy. Let us proceed on that. Please. I'm happy, he is happy. Because page 87 deals with that the original pleading which has to be looked into, not the new pleading.
Original pleading is in records.
Yes.
Where is it in record? It has
Yes,
been
it has to be. LCR has been tagged.
Cannot be. Original plaint was returned to you.
Yes.
Application. How can it be tagged with the record? What are you saying?
Lordship will kindly see the LCR tag is marking over there.
Sir,
LCR number is this tag. Lordship will see page 50.
was
I have
is it-
filed back. He has given back along with the new pleading. Lordship will see page 50 once.
old one along with
Yes,
the new
yes.
one.
Yes, Lordship will see page 50.
Then I'm directing that this 59 will
Yes, Lordship will
rejecting
see
this.
page 51.
I'm rejecting this plaint at page 59.
Yes.
I'm rejecting this plaint
Yes.
at page 59.
stand
You
with-
proceed with the
I-
earlier one.
Question.
You proceed with the no, sorry.
Page
I'm
50.
rejecting page 50. You
50.
proceed with page 59.
I proceed with page 59. Yes,
I'm recording your submission.
I do not know whether original.
Lordship will see page 50.
No, I'm recording your submission that it is on record and I'm recording your submission. You will not proceed with the plaint at page 50. You will proceed with the plaint at 59, which is already on record.
Which is already-
You have filed that.
Yes.
I think purpose is served. Mr. Shane cannot have any grievance with regard to that.
But that's my instruction, my lord. To the lower court advocate has to be, that's the only difficulty, my lord. Because we are not dealing in the Alipur court. We can come back after even half an hour's time. That can be. Within half an hour, just a phone call. Just a phone call. That's the phone call. But my instruction is there. Because LCR is tagged.
But
But she will see at
number
page
11.
50. Page 2 p.m. 2 p.m. Yes, yes. We can 12 o'clock also, my lord. 2 p.m.
So you will not press page 50,
50, I'll only go by
59.
But can we come at 1 o'clock, my
Why?
lord? 2 p.m. to Vishnu Chaudhary. Justice Chaudhary. 1 o'clock, 1 minute, my lord, 1:10.
Rising at 110.
1:10. 1:10. We'll come at 1. Just take that instruction. Yes.
And item number 11 is also related. Same party.
Same thing.
No.
Partition
No.
suit.
I'm not
In a
appealing.
partition suit, what has happened? I had to get an order from this court.
You are not
No,
appearing.
I'm not briefed in the party.
You were appearing
I
on-
was.
Kindly
Not in
tell
the
me that what has
application.
happened?
All right. No, is it related with this?
This is mother's will. I have challenged the mother's
So
will.
that is a separate thing because the issue may not be the
No,
same.
no,
Parties
issue-
may
no,
be
no,
same.
issue is-
So I will take it up. I will
Issue
take it
may
up. এইটাকে শুধু একটা দশে রেখে দিন
1:10. Deeply obliged.
110.
Deeply.
You said you will be taking not more than 5 minutes.
10 minutes, not more than 10 minutes. That's a phone call. And, no. 10 minutes.
For arguing, you will not take
No,
more
no,
than
1 minute.
1 minute.
Under
4 minutes for you to pass an order.
What fell by my lordship, I understood. My lord. Yes.
Yes, call the next matter.
Decree holder's application for expeditious disposal of eviction execution decree. Lord, the judgment debtor has filed an application.
After obtaining a degree, why expeditious hearing, Mr.
Order 21, rule 26 has
That
been
is
filed.
there in the statute.
In the same court. In the same court, they have filed without applying for stay in an appeal. The appeal is defective pending before the court.
And the
Nothing.
executing court is granting adjourn is
Unnecessary adjournments. Kindly not cease.
you apprise the learned executing court of the provisions.
Your lordship has much experience more than me. What happens? Repeatedly for nothing, my lord, orders at time is being done.
Mr. Kormukar, this is,
But for nothing time is being done. I could have understood.
show
for
me that
some
you have
genuine
cited the provisions of law, that it cannot be
reason.
stayed.
That order 21, rule 26 has been filed in the same court.
Maybe, Mr. Kormukar, in the same
That is
court.
good enough ground. Lord, what else do I need to show before lordship?
Then you serve Mr. Kormukar. Let me see. Can
The
we
service note again will take some. Lord, they have filed an application
service
there.
with some purpose. Service is with some purpose. This application under
But
Article
makes it
227 of the
then-
Constitution of
Lord, kindly takes up the matter once. Kindly, Lord, takes up the matter.
I will take up. Yes, yes. Next.
Lord, your lordship, Lord, will not be able to, Lord, reach.
Yes. Call the next matter.
Number 9.
There was a caveat.
I am for the opposite party caveator.
Lordship, the plaintiff is the petitioner before your lordship. By the order impugned, lordship, my application under order 18, rule 17 has been rejected at argument stage, lordship.
Argument stage.
Lordship, only one document that, lordship, I was authorized to give evidence, nothing more, lordship. Kindly comes to my application as
Manufactured authorization. Manufactured authorization at the stage of argument.
Yes, absolutely.
lordship,
Has to be.
order 18,
At the
rule
time of
17
filing of the suit, you did not give that authorization. At the time of deposition, you did not.
gave. Lordship, kindly see page
If you have
36.
given, then there is no necessity
No, that
to.
was an extract. Lordship, kindly sees.
Cross-examination started on 20th August 2010.
True.
It was concluded on 27th August 2014.
Where is Bagai construction?
9 times. Bagai Constitution. I am carrying my lord.
Lordship, yes,
Carrying.
lordship, just lordship, one document
Yeah.
only. I know, lordship.
My lord, I am served.
You have a rescue in 2011, 11 SCC, but
Bagai Constitution.
Bagai's construction is against you.
Para 9, 11, 12.
Para
9, 11, 12, 14, 15. Bagai Construction.
True.
paragraph 15 is the
15 is the, yes.
paragraph 14 and 15.
14 and 15.
Paragraph 14 last portion, paragraph 15. What is your answer to
True,
this?
but lordship will kindly take up lordship page 87, paragraph 3, lordship.
87.
Paragraph 2 and 3. That during the cross-examination held on 2010, the PW1 admitted that he could file documents showing his authority to proceed with the suit on behalf of the company.
Yes, 2010.
Yes.
So,
But subsequently, the PW1 forwarded the board resolution dated such and such to the conducting lawyer advocate of the present suit. However, the said document was inadvertently not filed, lordship.
Yes, they are admitting. They are not filed.
Yes, of course, I'm
This
admitting.
board resolution of 2003 you want to now produce.
Yes, yes. Lordship, the extract is already there, Lordship, at page 36.
You are the plaintiff.
Yes. Suit for ejectment, Lordship. She will kindly consider.
Section 6.
No. Yes, yes, section 6.
And my lord, I am carrying one more judgment also on this point. The scope of Article 227 is not that something like whatever it in Rule 17 get.
Give me that will be necessary when you come with 227 application as petitioner.
My lord,
Yes.
paragraph 10, my lord.
Yes, sir. If that was, this document was with them, it's a board resolution of 2003. So only for that purpose, what is
For that purpose, Lordship, nothing.
And only
only
one
for
thing,
the
my lord.
purpose of that, you'll be given a chance to cross-examine. Only one day I'm fixing.
Lordship.
They will come, all points are left open.
My lord, cross-examination concluded on, my lord, it's just purpose to delay the suit, my lord. It was already concluded.
Other points, only on that document, they will only
My lord, the main,
produce that, you will be
the
given a
main
chance to
difficulty is
cross-examine.
that, my lord, they realized this mistake when he was cross-examined. Only to fulfill that lacuna, my lord, they are doing this, which is not permitted. His law is clear, Honorable Supreme Court is
2009 4 SCC.
yes, my lord. Law is very clear that you cannot
That has
do
been
that.
that has been
At that
considered.
argument stage, my lord.
That has been considered. That is the
considered-
subsequent judgment
considered in
delivered by Justice Pardiwala, relying on 2011-11 SCC.
I've not got.
Considered in the, my lord, impugned order, my lord, also. Kindly see. This judgment was considered.
The 2011-11 SCC has been again affirmed in 2025 by Justice Pardiwala. Even considering this bagai.
That's why I'm saying that at this stage, my lord, it was not an
And
unreasonable.
even in 2011, 151, where is 2011-11 SCC? Then
No,
knew that it is not a fit case for.
No, no. Then, Lordship, I shall bring it, Lordship. I shall bring it.
It's a fit case for rejection.
I shall
Because
bring
you are sure prior to moving that it's not
No,
a
no,
case
no.
that it should warrant an order.
At
in
this
your
stage,
favor.
my lord. At this stage, my lord. When
Where is 2011 volume 11?
11, I'm not carrying it. I'm carrying Bagai construction on this thing, Amorkar, where scope of Article 227 is absolutely, it was abstracted that the scope is
there.
very limited. Very limited.
2011-11 SCC, it says at any stage.
My lord, may I read this for my satisfaction? My lord,
275.
paragraph 10, my lord.
এই এখানে বাদ করা যাবে 2011-11 SCC.
Lordship,
Page 9 of the judgment.
Yes.
Page 9, my lord.
Which
Last
paragraph?
Last line, my lord. Paragraph C.
Page
It
9.
is paragraph 10, my lord. And the next page, page 9 of the judgment. Page 9 of the judgment, paragraph C.
11 SCC
আরেকটু
275.
scroll করুন। Yes, done, ঠিক আছে। The inherent powers of the court, complementary. Yes, when exercising with cautious, there is no legislative guidance. Got a blank. কি একটু পরে হ্যাঁ একটু তুলো একটু উপরে the learned advocate for the respondent contest, once the arguments are commenced, there could be no reopening of the So this contention is raised by extending the no application will be once the trial or hearing is concluded and the case is reserved for is a sound rule but not a straitjacket formula. There can always be exceptions in exceptional or extraordinary circumstances to meet.
13.
You have the paragraph 13, subject to the litigation recognized with reference to neither the trial court nor the high court considered whether it was a fit case for exercise of discretion. ঠিক আছে। আসুন।
My lord, Bagai Construction considered this judgment. Bagai Construction, my lord, considered this judgment. 2000.
Bagai Construction considered this judgment, but that was the case when the matter went before the Honorable Supreme Court. The arguments were over.
Lordship, paragraph 15.
Consider this.
Yes.
15 in SCC, Lordship.
Paragraph 15, give me.
কেন কিছু আছে? ওইটা কি?
No, where is that paragraph has taken? Add a note of question 16. This application under Article 227 of the Constitution of India. So, where is The next matter.
Matter number 10.
Lordship, I appear for the petitioners in item number 10. Lordship, I appear for the defendant number 1 and 2. Lordship, I had taken out an application under Order 7, Rule 11.
Yes.
Lordship, I was not given an opportunity to file an objection to the Order 6, Rule 17 filed by the plaintiff. Lordship, the plaintiff seeks to amend portions which I have stated in my Order 7, Rule 11. Kindly, Lordship sees page 23.
You are not given any.
I was not given an opportunity to file my written objection to the Order 6, Rule 17. Lordship, on 4th March
So when
2000,
the application was filed,
Lordship, the application was filed on 9th June 2025
yes,
by
you did
Kutta.
not file. You were given opportunity.
Lordship,
Already
filed-
application was filed and today it was fixed for hearing and written objection in the meantime.
Lordship, the plaintiff had put up the matter. Lordship, they had filed the Order 6, Rule 17.
Show me the order dated 9th of June 2025.
Lordship, that is not
Has
annexed.
been recorded. Opportunity was given. What is the merits of Order 6, Rule 17?
Lordship, kindly sees page 23.
Yes.
Page 23 is an application.
What is the suit for?
Lordship, suit for partition, declaration, and injunction.
No, this is 23 is Order 7, Rule 11.
Yes.
Where is Order 6, Rule 17?
Order 6, Rule 17 is at page, Lordship. Page 38, Your Lordship.
38.
38 is the put-up application, Your Lordship. 39 is the Order 6, Rule 17. Lordship, the schedule is at page 41.
The shares have been stated. It's a partition suit.
Yes, Your Lordship.
Yes.
Page 41, they have stated the schedule. Lordship, we had taken out the point that the plaintiff.
So Order 7, Rule 11 was on that ground.
Yes, Your Lordship.
It has been
They
very
did take
infractious.
it out. They have again
That's
taken.
the law. Order 6, Rule 17 has to be taken up first. This application under Article 2
Item number 11.
I'm appealing for the
Partition suit.
This is the partition suit in
He's standing behind.
he was initially appearing for the main.
Then disappeared.
I got instruction in item 7, my lord. That is the reason I'm standing.
All observation seriously. Yes. Yes.
Partition suits of the mother's estate. My mother was also a party in that suit.
Mr. Chatterjee, which order you are challenging?
October 2020.
Last, my lord, 4th October 2021.
2021 in 2025.
No, I'll tell you, Lordship, my lord, why? Because I accepted this order and went before. Kindly appreciate, my lord. I said that what has the court said? Court said that I cannot pass a judgment because the probate proceeding is pending, which is in respect of mother's estate. Partition suit will title of the father is involved. There is nothing to do with the mother's estate.
No, the mother inherited the father's share.
No, even if the
mother inherited the father's share, then mother executed a will with regard to her, maybe her share as well as the.
Therefore, first, my lord, the title has to be decided. Title of whether it is the mother's property or not, or it is the father, because they are separate.
2021.
No.
What's the stage of the? What is the stage of the partition suit?
Everything done because the court that you have to complete partition suit. And on the basis, even after Supreme Court order,
evidence completed,
argument completed,
Notes filed. Notes
but,
filed.
Mr. Shin, the final.
No, my lord, but you will kindly have
preliminary decree that has to be stayed.
No,
because that depends. Because preliminary decree amounts to declaration of the shares.
Yes.
So if declaration of the shares it has to be made, without that will, who will get how much of shares to the mother, that is also relevant.
First is the title.
No, title, Mr. Shane, where's the
Will
dispute
not
with?
go into the title.
Will. Mr. Shane, I don't think there is a dispute. You are also challenging because you have filed a suit for partition.
Yes.
From the father.
From the father.
So father's title is not in dispute.
Yes, they are
Yes.
disputing.
Your Lordship will
Father's title is in dispute.
Because what they are saying is that it is the mother's Schedule C and Schedule D is mother's property.
But Mr. Shane,
Schedule A and
from
B, there is no dispute. So Schedule A and B, at least there
Mr. Shane, technically, partition suit can proceed till the passing of the preliminary decree. No difficulty on that. But when a probate is there, there are some line of decisions, Mr. Shane, you will be getting in Supreme Court in same volume in 2005. There are two decisions.
But
one says analogous hearing.
Yes.
Yes. So if this is analogous, so now it cannot be done because your suit has reached to the stage of arguments. Probate suit, as I have just now heard, it's still at the preliminary stage. So,
I was only
preliminary decree, Mr. Shane, preliminary decree cannot be passed. Even assuming preliminary decree can be passed, it cannot proceed further. Shares.
Accepted.
So, yes.
Accepted. But let my lord, the title issue be decided.
What is the dispute with it?
Yes.
Mr. Shane, it's your suit for partition.
Yes.
If you say that the father or the parties do not have unity of title and possession, your suit will be dismissed, Mr. Shane.
No. Schedule.
So you have to say, yes, there is unity of title and possession.
What is my structure of the plaint? Schedule A and B, father's property.
But 2021, first of all, that's the delay. Second is, Mr. Shane, it appears it is incomplete copy of the order.
Why? No, I think it is a.
It's not a certified copy.
The Lordship,
please kindly come to page 1 of your impugned order, last sentence.
Page 31, your Lordship will see.
Page 31.
Yes.
What is page 31?
That is the order.
No, order dated 4th of October 2021. It's at the annexed at the last. Annexed at the last.
So I think it is there in the beginning also.
Page 31.
Yes. But kindly just have a look at the order. How this suit has proceeded. Kindly see the suit is of 1994. Supreme Court orders were flouted. Then, my lord, a clause 13 application had to be taken out. Based on that, my lord, the suit was proceeding. Now, my lord, it is not that my structure of the plaint is Schedule A property is
Mr. Sen, the learned trial judge has relied upon a decision.
Yes.
2016 1 CHN.
I'll show your lordship the decision, my lord. That decision exclusively relates to father's property. One party saying that father has given by way of a will. So therefore, it had to stop until and unless the will validity is decided regarding the shares. Now here, before the ultimate shares are decided, Schedule C, which is the most disputed property, which I am saying that it is actually the father.
What is the plaint of this partition suit?
Your lordship will kindly have a look at. That is the most important thing. Share determination may wait. Kindly come to page.
So if the shares determination can wait, Mr. Sen, what remains?
Title. That
not piecemeal. No. Title, then shares, nothing.
But kindly have a look at.
Shares cannot be, because Mr. Sen, in the previous decree, the shares have to be declared. Shares have to be declared. So if you say shares have to wait, nothing remains.
Without the will, the shares have to wait.
Yes.
But at least the Schedule A and B can proceed. But
Not in piecemeal manner, Mr. Sen.
Your lordship knows, but partition, but there can be more than one preliminary decree.
Maybe. Maybe, but not. Mr. Sen, you cannot be affected because your suit has reached to the stage of argument. Everything has been done, evidence and other things.
But they are enjoying.
The probate proceedings can be expedited. So, and you have waited for 5 years, Mr. Sen. More than 4 years. You have waited for 4 years. I will try to expedite the suit so that
I have filed a expeditious disposal of the probate also.
that issue is there. I will consider, because now this application under Article 227.
For the father's probably
Not in a piecemeal,
70-year-old.
not in a piecemeal manner, Mr. Sen.
Otherwise, she will lose. She cannot proceed with the litigation. Kindly
Mr.
consider.
Sen, I'm quite conscious of the fact that the probate suit and partition suit, some issues are different. Some issues are different.
Yes.
But some are identical. But the fact remains, ultimate shares cannot be declared without that.
But A and B it can be declared. But kindly have a look at the plaint.
Not maybe, but not in a piecemeal manner. A and B, what will remain? A and B, others will be. So no effect.
I will get at least, my lord, the chunk of my father's property.
Those
are all being.
You will get everything, fathers and mothers both. Please wait.
The way the suit is proceeding, my lord,
4 years only on the ground of delay.
She may not live to see this. My lord, this is the
For
difficult.
4 years you could wait. That's the only ground for which this civil division application will not be entertained. This application under Article 227 of the Constitution of India is at the instance of the petitioner, is at the instance of the plaintiff, and is directed against an order dated October 4, 2021, passed by the Learned Civil Judge Senior Division, 4th Court at Alipur, in title suit number 20.
Seven will your lordship can dispose it of.
7.
Yes, that matter.
So wait, I'm coming after 5 minutes.
pleading in the Act 39 case is with the record,
Yes.
which is marked as tagged page 50. Page 50,
Yes.
in the new, on the new pleading, this LCR Act is tagged. This marking is there by the court below. LCR tag of Act 39, probate 18 of 13. Page 50.
50 is a new.
Yes. No, LCR may be tagged.
No, original is with the record. The original.
He is saying his submission.
So,
Yes, yes.
If it is not there, it is not there.
so you will
Not my
endorse,
submission.
you will endorse not pressed
Yes.
on this page
Yes,
50.
yes. I will endorse not pressed on the new pleading.
Yes.
On the new pleading.
On page 50. On the
page
plaint
50.
at page 50.
My lord. Yes. Yes.
Yes, Mr. Sen.
Yes. And your lordship, my lord, having regard to the last matter, your lordship will say that this
Yeah.
will be disposed of early, my lord.
No, this case, yes.
This has to be disposed of.
Even the last 3 occasions, they have taken adjournment for pending of this 227.
Yes, yes.
That because they have a valid ground to, because
Early disposal.
Very senior citizen, my lord. She stays in Bangalore every time she comes and nothing it takes.
They all are senior citizens. My client is
So
also.
you should be interested also.
so now you are only the contest. If this goes, you are only the contesting.
Yes, we called my witness. Everything is over. Chief over, PW1.
What is the stage of this?
Well, see the last order, my lord, the impugned order records on 13-1 for cross-examination of PW1 on recall.
Very well. We'll do it.
Cross examination PW1
One
means
on recall. My PW1, she has recalled.
all right. So
Continue.
recalling has been allowed.
Yes, it's continued.
Recalling was allowed.
Yes.
So
Will continue.
how many more witnesses? So you must be having some other. Who is PW1?
PW1.
Attesting witness.
Attesting witness. Attesting.
Attesting witness. How many more witnesses you want to?
Other, I think other witnesses have done. It is done. Recalling.
Other witnesses is over.
The
I
instruction
should
here,
give us 6-7 months time. A year's time to discuss.
6 months.
Six
Not
months.
Other witnesses are over, Mr. Sen.
just taking it.
And how many witnesses you will adduce?
One, myself.
Please take instructions. How many witnesses were there? Mr. Mittu, also you ask your
Sending.
because
Sending. By this time,
because it's your witnesses who are Ashok. This application under Article 227 of the Constitution of India. Push the learned district judge for
Very-
transfer.
Obliged.
Yes, call the next matter.
Obliged. This
Yes.
is for Lordship expeditious disposal of the probate suit of 2017, Lordship. Now, the executor.
What is the stage?
Stage, Lordship, it is fixed for hearing, Lordship, but the executor filed an application for addition of party that was rejected. Challenge before this honorable court. Honorable court rejected the application, directed the learned trial court to Lordship decide the suit within 6 months. But till date, Lordship, to the 13th February 2014, the order has been passed, Lordship. The suit has not been, Lordship, taken. Several adjournment has been taken by the Lordship, the opposite party. Lordship, kindly consider, Lordship, the order. Even Lordship, after rejection of the Lordship, order 1 rule 10 application, another recalling application was filed by the executor. That was also rejected.
This application under Article 227 of the Constitution of India is at the Yes.
But I'm the plaintiff in a suit for partition which started in 2004. Number the opposite party number 6, that is the defendant number 6 came up before your lordship and prayed for an order for expeditious disposal of order 12 rule 6 application.
Defendant number?
Defendant number 6 came up.
You are the plaintiff.
I'm the plaintiff.
Yes.
My lord was pleased to pass an order which appears at page 85.
Yes.
Directing disposal
What wrong
of
did I commit?
no. Your lordship was not pointed out, Lord, that there are other interlocutory applications pending. They only focused on order 12 rule 6 and your lordship directed that order 12 rule 6 has to be disposed of.
Yes.
So, I have come up before your lordship to say that instead of that order 12 rule 6 being heard, first, the other pending applications are there, the list of which, I can hand over to your lordship, but these are also to be, considered. But these are substantial applications, by both the parties pending.
But Mr. Mukherjee, what is the difficulty in taking up the order 12 first? Because order 12 is on admission from the pleadings. So if there is admission or no admission, why it has to await the decision?
Because your lordship will kindly have a look into the substance of the applications pending. There are receivers. The receivers removal are under consideration. There are petitions which are pending for depositing of the 30 lakhs which are appropriated by the defendant number 1A. So to avoid all these applications being heard and decided, they have come up with that order 12 rule 6 and took out an order from your lordship suppressing that other applications are pending. So it is not the case that only the plaintiff's application are pending. It is also the defendant's application are pending in substance. This is also an application under order 39 rule 7. There's an application for removal of joint receiver. Joint receiver is the plaintiff, my client, as well as a representative of the defendant. But what I pray before your lordship is I am not against the disposal. All that I say is that the applications which are pending and were not pointed out before your lordship for disposal, those applications should also be taken up together. Kindly have
your applications are earlier in point of time.
Yes. And kindly have a look at the last dates order by the trial court. The trial court, in fact, endeavors to take all the applications and hear it. And in the first paragraph, it has recorded my lord's order. which is at page 85.
List of pending applications. So today,
This is the list of pending applications I handed over. This was handed over to the learned judge.
today you have handed up.
No,
Today is the
today
date.
is the date fixed. 18th.
Yes.
Yes.
So you'll be handing up this list there.
Yes.
Ashok. Uh,
Lordship, the landlord is the petitioner before your lordship.
I am for the opposite party.
Lordship, the landlord has challenged an order where lordship 7-2 was disposed of, holding that lordship there was no due.
holding that there was
No due, lordship.
I have not been served, my lord.
There was no caveat.
Although there was no caveat, but I have not been served, my lord.
Lordship will kindly take up order number 13, lordship. That is the order impugned.
13 order
Number 13.
Yes, yes.
Dated 23rd of June 2025.
Yes.
Today is fixed for filing challans by the defendant. Both parties filed hazira. Defendant has filed rain control challans for the period February 2007 to August 2023. He has also filed a petition stating that the original rain controller challan for the month August 2007, November 2008 and June 2009 could not be traced. Peruse the challans filed. Parties have already heard in respect of 7-2 of the Act, Lordship. Having considered the same and also the rent control challenge filed by the defendant, it appears that the defendant has deposited rent from the month February 2007 till August 2023. Thereafter, the defendant appears to have deposited the admitted area rent from September 23 to June 24, and also for the previous month June 2006 to January 2007 in this court by way of civil deposit challenge in pursuance to his application under 7(1) of the Act.
When the
Though
suit was filed,
2024, Lordship.
how then from 2006 to 2007? Oh, this is the admitted areas.
7(1), pursuant to
Alright.
7(1).
Alright.
Though the defendant has stated to have misplaced some challan, it appears that the deposit of rent made by him after the month August 2007 and other months could not be traced out, were duly accepted by the office of the rent controller, thereby suggesting continuance of deposit of rent, Lordship. However, defendant would be under obligation to produce the missing challans as and when traced out, or the relevant information slip regarding deposit of the such period. And Lordship, it was held that there was nothing due.
Yes.
Is instructed by my client, my lord. Only 4 challans were missing. Out of 4, 2 got it. The information got it by my junior from the rent controller offices. And the
You have got the 2 challans. Out of 4, you have got 2.
only 4 challans, my lord. Only 4 challans.
Yes.
And out of 4 challan, 2 challan information got from the rent controller offices.
What information you have got?
There has been deposited the rent. The rent has been deposited for the particular period.
But that is subsequent. So you have not produced that while the passing of the order dated 23rd of June.
Subsequently, I have handed over the information.
So I am directing the learned trial judge to reconsider this. You produce whatever you, because unless you can show that all the periods of rent has been you have deposited, then you have to be held to be a defaulter for the remaining months.
Information slip has been provided me.
But for 2 more months also there is no document. So for that you have to
I have
deposit rent.
deposited. My client have deposited, my lord.
But you have to produce documents, sir.
definitely.
Without the documents,
This is very old challan, my lord. The department
that's a
also
different thing altogether.
for some time.
Ashun.
Lordship, another civil revision is also pending, Lordship, between the parties.
For what?
Lordship, Lordship, I challenge the order directing, Lordship, allowing them to deposit rent, Lordship, 7(1) order.
The 7(1) application has been
Because
filed.
Lordship, that was ordered that 1 month from the date of order they have to deposit. So that is also pending.
No, I could not follow.
Lordship, they have appeared in the suit within time filed 7(1) application.
Within time, file 7(1), yes.
The learned trial judge passed an order directing them to deposit the admitted area rent within 1 month from the date of passing of that order, not from the date of their appearance.
Chakravarti, the fact remains when the court has directed,
And pending, Lordship.
when the court has passed an order, how can the defendant be said to be at fault?
We have challenged that. That has been admitted, Lordship, by this honorable court.
The application has been filed
That is a
within 10
different
days.
thing altogether. Then it is to be
Then,
stated.
Lordship, we shall
You are for the plaintiff.
that
You are for the
publication.
plaintiff because I am directing.
Have it listed and then it will be heard at court.
Because the thing is that when the court has, there is no necessity to file any application.
True,
But-
that is why from 1 month from the date of his appearance.
Yes, but if the court has said so, can you for obeying the order of the court, a party should be faulted with the.
The court was wrong. That is why we challenged the order.
How can you? Yes, that's one way of looking at it. But how can you find fault with a party who is obeying with the order of the court?
Lordship, we shall move that application separately.
Move it now. I am passing orders.
We shall move it. It's not listed, Lordship. We shall.
Out of 4 challan, my lord, the 2 information has been got from the rent control department.
Yes, you produced that, but it was not considered while passing of the impugned order.
Yes, my lord. But subsequently, the court has directed me to produce the same. That's why I got
Produce
the
that,
information.
the court will consider that. They have to be also given an opportunity. What information you have sought for, they have to be given an opportunity for that. This application under Article 220.
Item number 15.
Lordship, this is my application. This is my application for expeditious disposal, Lordship.
Of what?
Lordship of an appeal, Lordship. Originally, eviction suit was filed in.
Appeal is pending.
Appeal
What is the
pending.
stage?
Lordship, argument stage, and in the meantime, Lordship.
Argument stage.
Argument stage, Lordship. Because this is an eviction appeal, Lordship, at the time of admission.
What argument stage?
Lordship,
151 application.
151 application is for depositing the occupational charges by the appellant which he have failed. Lordship, this was the condition for stay of the execution proceeding. Lordship.
So you are for the respondent.
I am for the respondent landlord, Lordship. I have got the decree in the suit, Lordship, and tenant filed this appeal, and now, Lordship,
This application under
just delaying the.
But I am for the opposite party.
Time
Yes.
for the petitioner, madam. The order 9, rule 13 was allowed. I have challenged the order. The fact.
Allowing you are challenged.
Yes.
Why?
3 times, my lord, the summon was issued and it was served. If my lord will kindly see the impugn order, my lord, there is no observation to that with regard to the bailiff report. My lord, I have personally seen the record of the lower court. The bailiff has served the summon on 2 times with an endorsement, and there is a report to that effect that when he went to the property for service of summon, no one was there, and she has made a note and affixed the summon on the outer gate of the property and affixed the plaint also. And well, the track report says the defendant has personally received the summon on 2 times. I will show the track report.
Yes. What is the suit property?
The suit property. If my lord will kindly come to page number 22, my lord.
What is the suit property?
And page 22, my lord will find the schedule.
Yes.
All that, my lord, may I read, my lord, if my lord.
No, 2D/1.
2D/1, Embassy Building, 2nd floor, measuring about more or less 4 Shakespeare Saloni, Kolkata 71.
When summons was served according to you?
Yes, my lord, I am. But if my lord will kindly come to page 16 once. If my lord.
Just give me the date. I will come to the documents thereafter.
Yes.
Please give me some dates.
My lord, the first summon was served on 6 December 2014.
6 December
2014. My lord will get the page number.
Why first summons?
My lord, 3 times the summon was issued.
Why 3 times the summons was
First
issued?
time when the summon was issued, we have filed the postal receipt to that effect that the summon was served along with the track report with the application that the summon was duly served.
If the summons was served at the first attempt, why subsequent attempts?
Because my lord, the court says, my lord, I have the order, the learned court below says to make a second attempt. We have
That
accepted.
means the court was not satisfied with the first summons.
Yes.
Yes. So first goes.
Yes.
Next, second.
Yes, my lord, I am coming.
Second, when it was served.
My lord, if my lord will kindly come 22 May 2015.
22 May 2015.
Yes.
How it was served?
My lord, by a postal mean as well as the bailiff report, as well as by way of a summon bailiff.
Yes.
My
So
lord,
why
the summon,
third attempt?
my lord, the second when I'm showing the third, I'm showing the second attempt.
No.
Thereafter,
Why second? Why there was a third attempt?
My lord, the third attempt when the 2 times the summon was served,
the court says the summon was not duly served. Thereafter,
But you did not
yes,
challenge those orders.
yes, yes, my lord, we have accepted again. We have filed
So
the.
now is the third summons when it
But
was
this,
served.
I mean, I have given a particular of third summon
Yes.
on 22/5/2015. This is a
So
particular
second
of.
is 22/5/2015.
No, my lord, this is the third, my lord.
So what was the second?
And the second, well, I am showing.
All right, so this is the third.
Third. My lord, this third
Show me the
time,
third service.
yes. My lord, the third time when the summon was served, we have made the order 6 rule 17 application to add one more address of the defendant.
Why?
Because, my lord, because on the two time when the summon was not served, we have filed the application under order 6 rule 17, praying for incorporation of one more address of the defendant. That was allowed. Again,
So why you wanted, the defendant was present there. So why you wanted the addition of another address?
Yes, my lord, because the problem is that, my lord, because the summon was not accepted by the court, for better precaution, we have made the we have put the address of the other address also. But if my lord will kindly come, I am showing the plain.
So the defendant has two addresses.
Yes, right now, my lord.
At the point when the summons was served also.
Yes, my lord.
Yes, show me the what is the other address?
Yes, my lord. If my lord will kindly come to page 28, my lord.
Page
The amended
28.
plain.
Yes. Yes.
My lord, 38 Shetro Mohan Naskar Road, Kolkata 40, as well as the suit premises, my lord.
Yes. Now third service is only at 38A.
No, my lord. The third service on two ground, my lord. The third service of the suit premises says page 39. If my lord will kindly come.
39.
Page 39, my lord will get the track report.
Yes.
My lord, the last line, the summon was item delivered to the defendant. Her name was there, Projori Avinash. And she is the defendant in the suit.
Sir, item delivered.
Item delivered.
When?
My lord, 22/5/2015.
Sir, on what happened on 20th of May 2015?
My lord, first, yes, my lord, I have made a circle to that effect that firstly it was refused, again item delivered.
So where was the occasion of again retendering when it was refused?
Well, I do not know. It says the one more thing. If my lord will kindly come page 40. My lord, the proper where the second service, where the third service was made in respect to the other address, it was returned unclaimed.
No. Please proceed
Yes,
slowly. Page 39 is at which address?
Yes, page 39 is at the suit property.
Is the suit property?
Yes, my lord.
My lord, if I may just interrupt.
Madam,
this is
please, I will
suit
come.
property. This is not the suit property. my
39
lord.
is not the suit property.
My lord,
Yes,
this
I will
is
come
the-
back to you.
I found it my duty to point out. This is not the suit property.
I'm checking again. I may be wrong, my lord.
Kolkata 4039 says it's Kolkata 40. That is the other address which was pointed out.
So 39 is the other address, 38A.
Yes, my lord, maybe. I beg your pardon. My learned senior friend is correct, my lord.
So this is not the suit property.
This is not the suit
That is
property.
38A.
38A.
Yes.
And my lord, the
38A.
second one is the suit property.
40 is the suit property.
No,
40
40 is not the suit property. 71 is the suit. Kolkata 71 is the suit property.
40 is also not the suit
Which
property.
is at page 40. My lord is right.
Yes.
40 is the suit property.
Yes,
Page 40 is the suit property.
So 40 is door locked.
Door locked.
Intimation served.
Addressee absent. Intimation served. Delivery
So if
attempted.
it is door locked, to whom intimation was served?
Well, there was an endorsement to that effect, the unclaimed also.
That is why I'm unclaimed is, sir, where is the endorsement of unclaimed?
My lord will get the 27 May 2015, my lord will get delivery attempted unclaimed. Well, I have pointed out, well, after addressee absent,
so absent.
Addressee absent, delivery attempted unclaimed.
Yes, so first is door locked.
That
So
is
to whom intimation was served if the door is locked?
Well, for the time being, let us consider that if there is a postal report says that if the track report will consider. Well, at the time of disposal of order 9 rule 13, there are two prima facie. First, my lord, I have shown the postal facts of the case. The second one, my lord, well, if my lord will kindly see the impugn order, in the impugn order, my lord, there is no averment, not a single line of when deciding order 9 rule 13, what about the service with regard to the summon belief. And my lord, I have personally gone through the record. the summon bailiff has made the attempt on 3 times, and on the last second 2 times, my lord, he has made an
Earlier times, because when
yes,
the
yes,
third
it's correct.
third
No,
order is directed
yes,
to
yes, yes,
previous those,
yes.
everything.
The court
The
will
court
only
was not satisfied
yes,
with
the
the
court will-
earlier.
court will
So
not
now
discuss-
this is the last one. Page 40 is the door locked.
Page 40 was the door
If
lock.
the door is locked, to whom the intimation was served, sir?
Again, my lord, I am telling, my lord, if my lord will kindly see the bailiff
Second
report.
is addressee absent.
Yes.
It might be intimation served.
Yes.
But door locked, no intimation can be served.
My lord, if my lord will kindly see the bailiff report, if my lord will kindly see the summon bailiff report, it will be clear to your lordship, my lord. The
This is
summon
not the summon bailiff report, sir.
no, my lord, I totally agree. But my lord, in the summon,
I am on page 40. I will
Yes.
come to the summon
page
bailiff
40,
report.
it may be, my lord. My lord is somehow
But
correct,
this
my
is
lord.
the final report of the service of summons on which the court proceeded ex parte. So previously we can, for now, we can keep it aside. So this is page 39 is the other address where also there is a dispute, because if it is refused, then there was no occasion to again deliver. So this also cannot be relied upon 39, and 40 is also a difficult thing to digest. So when it is door locked,
This is my lord, for the time being, let us consider that the postal report, the postal summons says that there is a dispute. Let it be set aside. My lord, the second point, the summon bailiff. My lord, the summon bailiff.
When did he serve?
Yes, my lord. Well, I have. The date was not there, but in paragraph 11, I have stated. My lord, yes, my lord, if my lord will tell my lord, I will apply the certified copy of the summon bailiff report. No issue, my lord. And my lord, if my lord will kindly see the evidence at the time of disposal of Order 9, Rule 13, court will see that the summon was not duly served. But that is our case, my lord, that the summon was not duly served.
Please kindly come to page 174.
174.
Yes. This is your evidence.
Yes. Yes, ma'am. Page 174.
So you have admitted that the opposite party hearing of the petitioner in the miscase never resided at Khetramon, Noskor after her marriage with my son. So why did you incorporate that address? It's your admitted case that she never resided there.
My lord, again I am saying, my lord, for the time being, let us consider that the postals will not consider.
No,
My lord,
on the basis of your evidence, your conduct shows there is something.
No,
Yeah.
my lord, when the summon bailiff went to the suit property 3 times, well, I know that the 2 summons will not be considered. The 3rd summon says it was duly served. As per the bailiff report. My lord, if I will satisfy the bailiff report, the court will may come into the conclusion.
Where is the bailiff report?
I have personally applied for the certified copy. I have told to the learned court below, but there is a general practice of the city civil code that until and unless the document will be marked as exhibit, it cannot be obtained as a certified copy. So my lord, kindly fix a date. I will come and put a writing and file it before the court. If the court will not allow me to obtain the certified copy.
So this was allowed, the suit is proceeding.
My lord, the suit, yes, my lord. Well, kindly see the date is fixed for my lord. I am showing, my lord.
Yes, so decree for recovery of possession.
Yes.
So have you taken possession?
Yes, my lord, the possession has been delivered to me. I have got the possession. After getting the possession, my learned senior friend has come before the court below and filed 9 Rule 13, claiming that I have got the knowledge on that date. So my period.
Restore back possession.
My lord, my point.
Restore back possession. Again get a degree.
No.
That will be repossessed.
My lord, kindly give me one time. I will satisfy to your lordship by filing a summon.
No. You can take your time. No problem. Please deliver possession.
I'm yes, well, I'm undertaking that till the disposal of the civil revision application, I will not alienate or
please,
create a
please
until
over
and-
possession
no,
first.
until and unless my lord, if my lord will kindly allow me to satisfy any date.
Whatever is there, again it will be retransferred to you.
I know, that is the law. I know, I know. Kindly give me some time to satisfy your lordship. If I will not satisfy, my degree will go. I am not stand on the way. Kindly give me.
Has gone.
Gone. I know. It has been affirmed.
Gone.
It has been affirmed by the.
You are liable to return possession.
Kindly fix a date. Kindly fix a date.
Predeceased son, widow of predeceased
My
the petitioner number
the suit.
sister-in-law of the petitioner number 1, my lord.
My suit.
So there is something in this.
Kindly.
This shows from amendment your conduct. First, you failed in 2 attempts, then amendment, third address, and you in your evidence have admitted she is not residing, showing that you have obtained a decree.
For the time being, I totally agree. I will only argue on the law point. If law is my against, the court will pass the order. Kindly give me some time. I will come.
After some argument, the learned advocate appearing for the petitioner prays for an accommodation to produce the orders passed in the suit in support of his contention that the summons was duly served. First up, on the prayer of the learned advocate for the petitioner, list this matter in the monthly list of November 2025 under the heading motion. First up, it is however made clear that pendency of this application shall not be a bar in proceeding with the hearing of the trial court in the meantime.
I'm grateful.
Yes, next.
Item number 17. In item number. Order has been passed by the the petition was filed by the defendant and that was allowed. Subsequently, lordship, it's come to our knowledge and we made an application under order 39 rule 4. The matter was put up for several occasions, lordship, that the court has fixed the date on
order 39 rule 4.
Order 39 rule 4, lordship.
It is pending.
It is pending, lordship. It is pending for adjudication for 31st of October 2025. So my contention is that
Order
lordship,
39 rule 1 and 2 is also ready.
order 39 rule 1 and 2 filed by the defendant, lordship, that was allowed.
Order 39 rule 1 and 2 filed by the defendant or the plaintiff?
No, I am in response.
Order 39 rule 4 you have filed.
Yes,
I am
fine.
asking you, order 39 rule 1 and 2 is ready for hearing.
No, lordship, it is not ready for hearing.
Filed written objection.
Lordship, we have filed the written objection.
You have filed written objection to
that
order
has-
39 rule 1 and 2.
No, we have preferred an application under order 39 rule 4 because there is a gross violation, lordship. They have misrepresented.
Application under
Lordship, we will consider.
For the petitioner, my lord, this is my application for expeditious disposal. My lord, a matrimonial suit was filed by the wife, my lord, on the ground of cruelty for dissolution of marriage under the Special Marriage Act. My lord, in the meantime, my lord, we have written an.
Any order for alimony?
No, my lord, not yet. No.
Not yet.
No.
What is the stage of the
My lord,
matrimonial?
stage was that in the meantime, my lord, I came to know that
You
the
are the
decree
wife.
was a nullity. Yes, that the marriage certificate was in nullity as the registrar at that point of time had long back been ousted as the registrar by the registrar of marriages. My lord, that I came to know from an information given to me in an RTI application. Immediately, I filed an application for amendment for including, my lord, for declaring the marriage to be declared as nullity. What happened, my lord, in the meantime, my lord?
Application is pending.
Application is pending.
Application under Article 2.
Yes, my lord, only if, my lord, the suit be expedited, your lordship.
This application. What happened on 4th of August? They have appeared.
4th of August.
Yes.
Yes, we have entered appearance.
But directing, what is the next date fixed? And directing the miscellaneous appeal to be disposed of.
Your lordship, interim order is standing, steering. Interim order, I have been restrained from working.
What is the next date?
The examination.
What is the next date fixed?
28th August.
28th is only 10 days.
In the meantime, examination are going on. Unnecessarily, your lordship can see the order.
Mr. Ghosh, it was from 4th of July. So it has been fixed on 4th of August. You have entered appearance. 18th of August, I am directing the miscellaneous appeal to be decided.
Your lordship, in the meantime, what will happen? Lord, the students, the examination are fixed and the principal, they have not appointed somebody who has crossed the age and the affiliating authority has not approved her appointment. I am continuing. So kindly see, Lord, what happened. In order to avoid, Lord, any further, Lord, siphoning of the fund, we, in a notification, the student not to deposit cash deposit, but in the bank account. Immediately after that notice, they filed a suit behind and back and stopped the bank accounts. And Lord, through the principal and issued a notice, you pay cash. Lord, in these circumstances, everything is being done by them. And Lord, their maximum member of the trust would be 11. Now they are 14, 13. All these things have been done.
Mr. Ghosh, this has
kindly see the documents.
Mr. Ghosh, this is to be hard.
Lord, before that, Lord, your lordship kindly allow us to file our written objection.
Yes.
And Lord, in the meantime,
I am allowing you to file a written objection. I am directing it to be taken up on the next date. And if you want to file a vacating application, you can also file that.
In the meantime, what happened?
In the meantime, Mr. Ghosh.
Lord, kindly see that what is, how they have got, and kindly see the order impugned.
Mr. Ghosh, this matter is to be heard on merits. Then I have to fix the date because this is to be heard, Mr. Ghosh.
Lord, kindly see this judgment, this order impugned.
Yes.
Lord, whether it is not at all maintainable. This is not order. Kindly see the impugned order. Once, Lord. It has not followed the Lord settled principles.
Yes.
Yes. Lord, kindly see the impugned order. Yes.
You have been terminated.
Lord, that is what that resolution is bad.
Then Mr. Ghosh, if there is a termination, then you say that is bad. You have to challenge that.
And Lord,
Mr. Ghosh, if you're
Lord, kindly see termination also without any show cause and
then you have to challenge that, Mr. Ghosh. How can you now set aside without there any challenge
Lord,
to
who
that
has
effect?
terminated? Can you see who have terminated?
Mr. Ghosh,
So
then
they are kindly
I
see, Lord.
Mr. Ghosh, I accept your submission that they do not have any authority.
Yes.
But you have to challenge that order of termination. You have till now you have not challenged that.
Lord, I have
challenged that.
Lord, I have said I have filed my letter has sent. Lord, kindly see the resolution by which it has been terminated. Lord, kindly see once.
Mr. Ghosh, then all these things have to be gone into. Till now, good, bad, indifferent, you have been terminated, rightly or wrongly. So, but that is also not under challenge here.
Lord, that has not been accepted by the affiliating authority. I am still there. That
has not been
resolution has been
accepted
not
by the
affiliating authority university. I am still there as principal.
This requires an acceptance by the affiliating authority.
Yes. Otherwise, nobody can function.
Mr. Ghosh, all these things, rules and other things have to be gone into. I can fix a date because ad interim, it cannot be stayed. Order of injunction.
But in
Mr.
their
Ghosh,
presence, it can be heard.
then I have to fix a date because all these have to be gone into. Or I can give you liberty, you can file a vacating application also.
Lord,
I can direct.
my Lord knows what will happen, Lord. It will take several months.
No, I am directing. The 18th is the next date fixed.
Yes.
So I'm directing
28.
I'm directing the miscellaneous because this is only against ad interim. I'm not. I'm only directing this miscellaneous appeal. That is the only scope. Nothing. Records are also not needed. I will clarify. No calling for the records. Only on the basis of the documents which were there. I will direct.
They have not annexed my documents at all. Only thing their documents.
Stop them from
I'm giving you liberty to file a written objection or the vacating, whatever way you want.
Yes.
So within a time, give me a time, within 1 week, you file, I will direct the miscellaneous appeal to be disposed of, to be taken up on the next date. 28th.
I can do it, but once more can see the impugned order. What is the reason which has happened? Not followed the principle laid down by Stanley Morgan.
No, I follow, but only thing, Mr.
Considering the documents, like page, this is page 3. This is last. Considering the documents, it appears the defendant threatened and intends to dispose of the property nowhere in the case made out on the plaint. The property of the trust, when he is not in a position to deal with the financial matters, I have not done. I have not in charge.
Of course, only difficulty is that.
The third case.
I appreciate that. But vacating this will amount to setting aside the order of termination indirectly, may not be directly. That's the difficulty. Because the order of termination, your order of termination is staring at your face. That is not under challenge, good, bad, indifferent. You can set it aside, you can make those submissions because you have to now have only to look into their plaint and the documents.
And that's why I have no scope to do anything. That's why I have not done anything, said anything.
That is why I have given
on the very face of the order itself. If your lordship think that it is justified order, then Lord, I have nothing to say. But kindly see, Lord.
Only thing, Mr. Ghosh, is troubling is letter of termination, your termination. That is only the troubling part.
Lord, your lordship once see the resolution of termination. Kindly see once.
Yes, show me.
Lord, your lordship straightway come to order of termination, Lord. That is 73. Page 73, Lord.
76.
73 is the resolution.
73, yes.
Yes. Lord, kindly see what I have written, Lord, regarding the allegation that has not been disclosed in the resolution. They said it has been placed in the meeting and
but you are absent. You are absent, Mr. Ghosh.
Yes.
You are Dr. Sudipa Chakraborty.
Yes.
You are absent. Why were you absent?
Lord, I stated that you cannot form a meeting, not the trust. This board is not valid.
You could have attended the meeting and said
No,
this.
when the board is not valid, because your lordship, like he has no right to call for the meeting. I am the only person entitled to call the meeting because I am the not the settler trustee and not I am the managing trustee. That is the clause 9 of the trust deed.
Mr.
And
Ghosh,
that
then if you want me to look into this, I will fix a date. I will hear this because, but interim, it cannot be stayed. Or I can give you liberty to file because here I cannot look into your documents.
No, my document I have not given, their document.
No, that is why.
That's I have limited my case within the scope of their documents and
I
pleading.
appreciate that. So, or I can give you liberty to file your objection to their application, and I will direct the miscellaneous appeal to be decided on that day.
Objection. Lord, your lordship, Narayan Bose, your lordship knows, he has done everything. Some political persons, Rothin Ghosh, minister in charge, everybody has taken and everything has installed. Lord, through police, Lord, everything. Lord, I have stated.
Much has been written in the petition also.
Narayan Bose, Lord, your lordship. Yes, that is fact. Lord, that is Tutu was doing proceeding. Therefore, he is there, Lord, political persons have been Rothin Ghosh and some councillors. And through political, Lord, the involvement, everything is solved.
I appreciate it. That is why you are before a court of law.
Lord,
I give you liberty to file objection
I
to
shall
make out.
confine myself within their documents. If your lordship kindly.
Or I can do one thing. I can also direct the injunction application to be disposed of. You file a written objection to the injunction application. Trial court.
Trial court.
Yes, I think that will be better. What is the next date fixed in the trial court?
Trial court.
What is the next date fixed?
It is appeal court. এই কেসটা নেক্সট ডেট কবে দেখো Lord, your lordship kindly 1 minute. When the trial court fixed the date, Lord, I'm just check. Trial court.
Oh, 18th of November.
Yes.
Because the trial court has rejected the prayer.
Yes.
So I can do one thing. I can direct you to file a written objection because preponing Mr. Ghosh may be a difficult thing.
November, it will not be done. Lord, your lordship, then Lord, the appeal court.
I can direct the appeal
can
court.
Be done.
Yes.
But no, only one thing kindly see that.
Mr. Ghosh, I can do one thing.
And but the learned appellate
do
court,
one thing because
not a single whisper regarding the trial court, why he has rejected it.
I can do one thing. Without giving you liberty to file written objection, I give you liberty to file a vacating application. Because vacating, suppression and other things, you can take that point. I give you liberty and I direct because miscellaneous appeal against an ad interim, by filing objection, it cannot be improved because the court has to consider that. Only one thing is that window is with regard to Order 39 Rule 4. So Order 39 Rule 4, I can give you liberty to file a vacating application. I direct that application to be taken up on the next day. So you have your pleadings there with regard to the suppression.
Yes, but that will be there. Because that's why, Lord, in view of this illegality, I only confine myself within their pleadings and documents. And Lord, this state, he has introduced the political person in the trust. And through that political person, Lord, through police and doing all these things.
So 28th is the next date fixed.
28th August.
Yes. 28th of August.
Mention next date. I am not getting it in the portal also. So
no, Mr. Ghosh is staying on the 28th of August.
Is 20th.
Ashun. The
their exchange of the affidavits. Otherwise, not.
That I will do.
Yes. Great.
Item number 20.
Yes, Lordship, I beg for the petition, Your Lordship. This is a prayer for expeditious disposal of an application dated 4th April 2025 for impleadment of party. The petitioner is the applicant who has filed this application for being impleaded as a defendant in this suit. Copy has already been served and the suit is ready for hearing. The next date is fixed on 28th August for hearing.
What is the next date fixed?
28th August. And the petition was filed on 4th April 2025.
This application under Article 227 of the Constitution of India is at the
I'm led by senior advocate Mr. Protein Boy. I'm paying for accommodation for 1 day.
Your Lordship, in item number 21, I am appearing on behalf of the opposite party. We filed the caveat, but the caveat expired due to my fault. It not be extended, and after the caveat time expired, they filed this civil division application. Matter is pending before
Evidence is going.
evidence is going on before Your Lordship, before the court below.
Paying for an accommodation for 1 day. Mr. Patra Protein Boy is in outer station.
That cannot be a ground for adjournment.
Your Lordship, the impugn order was the 7-2 application has been rejected on the ground of limitation.
On the ground of
limitation?
Yes.
Your Lordship, I'm paying for him 1 day. I'm not. Your Lordship, I'm not the advocate. I have not been briefed into the matter. I have no idea about it. Your Lordship, kindly paying for an accommodation for 1 day.
Advocate on record. Ask him to come.
Okay, Your Lordship, kindly paying for an accommodation for 1 day, Your Lordship. Or kindly pass over the matter.
Yes, pass over. Pass over. Give him a copy. Pass over. Item number 22.
22, my lord, I appear for the petition.
Yes.
My lord, there is a civil division, my lord, against the order dated, my lord, against the order dated 29th April 2025.
Yes.
Now, my lord, in this, in a nutshell, my lord, may I, in 5 minutes, may I, my lord, just summarize. My lord, in 2018, an award was passed. The petitioner herein is the award debtor, my lord. Is the award debtor, an award was passed against the petitioner. And in 2019, execution under order 21 rule 11 was filed, and my lord, since 2019, my lord, the execution is pending. In 2023, my lord, there was an order passed by the learned executing court. The bailiff took possession of all the properties, symbolic possession of all the properties mentioned in the execution application. Now, my lord, 3 properties are mentioned in the execution application in this tabular statement. 1 are 4 car parking spaces, 1 is the office space, and there are 75 shop rooms in the Rajbihari market, the main market, my lord, opposite to Kalyan Jewelers, Rajbihari market. Now, my lord, in this particular order against which I have come before your lordship, my lord, all the properties have been attached and sale proceeds have attached, my lord, whereas I have specifically pleaded in my order 21 rule 64 application that I am ready to give away the 4 car parking spaces. 44 lakhs was the, my lord, arbitral award at the time of filing of the execution. My lord, that is back in 2019. Thereafter, my lord, I have paid some amount, some meager amount, 2 lakhs at certain occasions I have paid. Now, my lord, their main contention of the opposite party is they want my 75 shop rooms, which are of the members of the association, the petitioner association. My lord, 75 shop rooms amount to almost 2 crores per shop room, my lord. That is more than 150 crores. My lord knows the judgment of Takasela Peda, my lord, that the decretal amount, if satisfied, my lord, there are no.
Satisfy the decree.
My lord, I am ready to satisfy, my lord. They are taking.
If you are ready to satisfy the decree, this order of attachment could not have been passed.
My lord, may I, my lord?
How soon can you pay the amount?
My lord, I am ready to give away those 4 car parking spaces, but they have attached all the properties.
Show me the decree. Show me the award.
Award, my lord, I have not, my lord, award I have not attached, my lord. Award I have not.
Give me a copy of the award.
My lord, I will. Hello.
Where is the execution application?
Execution application is, my lord, at page 49, my lord, 49 onwards. That is, my lord, the 21 execution application.
What was your objection, written objection to the execution application?
My lord, I have the written objection to my execution application. My lord, I have no written objection to the execution application. My lord, I am ready to, my lord.
But you have filed a written objection.
Yes.
You have not said that you are ready to. Then withdraw this application, file an application before the executive court that you are ready to hand over the 4 car parking spaces.
May my lord kindly takes, my lord, page number.
So you are ready to comply with the.
My lord, I am ready.
So,
but my lord, all these.
So withdraw this application, take out an application before the executing court saying that you are ready to comply with the decree award.
You know, they are, what is my difficulty, my lord? That is 75 shop rooms they are attacking on that shop room.
Hand over them 4 shop rooms, then they will not do.
I am ready to hand over, my lord. I have stated, my lord, I have stated.
Show me from your written objection you have stated
my lord,
that you are ready to. Show me from your written objection you have stated that.
My lord, just. My lord, kindly takes, my lord, order, page number 32, my lord. That is my application under order 21, rule 64, 65 and 66.
Yes.
That is my application, my lord, that I have told them to proceed with the sale. I have submitted before the court. Now
proceed with the sale. Sale of what?
My lord, the 4 car parking spaces. And, my lord, the office space also. If
what was the decree? What was the
award? The award was, my lord, a monetary award. My lord.
Yes, show me.
Yes. That will, my lord will find that in
pay off the amount.
I am ready to pay off, my lord. I am ready to pay off. I am ready to, my lord, give away the 4 car parking spaces. And if any amount is outstanding, because I bona fide believe that when those car parking spaces will be sold, the decretal amount will be satisfied in its entirety. And I have also stated that in my order 21 rule 64 application. My lord, page 52 onwards, my lord will see, my lord, at page 52, my lord, the decretal amount, the award amount, my lord, 44 lakhs 16,360. This is column number 7 of the tabular statement.
It's not very legible, but you have annexed. How soon you will pay this amount?
Lord, I will pay this amount within, my lord, before the next date also. If they, what has happened?
What is the next date?
Lord, sometime in November.
November cannot be stayed. You pay off within 31st of August this amount.
This amount, my lord, I am ready to give them the 4 car parking spaces. I have also.
Let the other car parking space remain attached. As soon as you pay off, that will be released. That's the best way. That will.
If that is, my lord, I am.
So that has been done. So no difficulty in that.
And my lord, kindly, my lord, takes Kindly, my lord, page, my lord, page 34. That is my application that I have stated, my lord.
Page 34, yes.
Paragraph. Paragraph 8, my lord, 7. Paragraph 7. In the said written objection, the judgment letter number 1 expressed that in order to execute the arbitral award, the Danette court should
Page 34, paragraph
page 34, paragraph 8, 7, my lord.
7, yes.
In the said written objection, the judgment letter number 1 expressed that in order to execute the arbitral award, the Danette court should conduct a sale to court under order 21 rule 65 code of civil procedure. My lord, they are again taking out applications day after day, my lord. I am ready to pay, and each and every day, my lord, the interest is also accruing. I am ready to pay, my lord, but I don't have the money as on date. My lord, I have the properties. My lord, 4 car parking spaces. My lord, kindly appreciate that 4 car parking spaces I am ready to give away. But 75 shop rooms, it's a huge amount, my lord. 44 lakhs award, my lord, accruing interest, it will come
Car
down
parking space is being sold at 11 lakhs.
11 lakhs each.
Each.
Yes. And the rest I will pay, my lord. I will pay. The rest will be remaining around 5 lakhs to 7 lakhs. That I will pay, my lord. I will collect money from all those shop owners, 75 shop owners, because I am an association. And these 75 shop owners I have shops in that premises, my lord. And all that shop owners, all of those shops have been attached, my lord. And my lord, they are attacking my shop.
That has been attached in the month of April.
Yes, my lord.
So you are challenging in the month of August. So it has remained attached for this. You did not take care to pay off these amounts.
Lord, I am ready. Lord, I am ready to pay. Lord, I am whatever I.
Within August, you are ready to pay. I am recording your submission.
Lord, I'm
Learned advocate appearing for the
Lord, kindly appreciates, Lord. Lord, those 4 car parking spaces, Lord, may be sold off. Lord. Maybe sold off, Lord. Maybe sold.
You pay off. Who will sell off? You sell off.
There is an attachment. How can I sell off, my lord? There is an attachment.
Apply before the learned trial judge that I give you liberty. You go before the learned trial judge for removal of those attachments that you will selling of this. You procure purchasers with the money that will be deposited.
My lord, if I am not able to, my lord, then again, if I am not able to sell off, my lord, then again, it will come down to, my lord, the same. My lord, kindly clarifies it, my lord, that 1, 2, and 3, the schedule, my lord, if my lord takes the schedule of the order 21 rule 11 application, the tabular statement. The first is that 500 square feet office room that I am also ready to give off if it is required. Second is 4 car parking spaces. In the schedule, third property is all those 75 shop rooms. Now they are attacking those 75 shop rooms and they are wanting to sell that off, my lord. And that is my
balance amount you will get. They will take away their balance amount you will get. No difficulty in that.
Kindly, my lord, clarifies, my lord,
They will not get more than the decretal amount. That much I can clarify.
That, my lord, kindly clarifies, and my lord, that's 4 car parking spaces, and my lord, kindly my lord, passes a direction, if my lord pleases, that the schedule, as per the schedule, my lord, 1 to sale might be conducted as per the schedule of the order.
Make a prayer before the executing court that 1 to 4 those sale may be conducted. Make a prayer. Make a prayer with regard to that. Your prayer is not that here. Have you said that you are ready to hand over those 4 car parking space?
Application, my lord, I have said. In my application of order 21 rule 64, I have stated, my lord. In my application. My lord, that order, that page 34, my lord, that very next paragraph.
How soon you will be paying this amount?
As soon as, my lord, if what I can, my lord, offer is that 4 car parking spaces which has been attached, my lord, those may be sold off through court procedure. Those may be sold off. My lord. I have no problem. And the rest amount I will pay within whatever time, my lord, will prescribe. Whatever time, my lord. The rest amount after selling of those four car parking spaces.
The learned advocate Item number 23.
Lordship, item 23, I am appealing for the petitioner. Lordship, the sequence of events is the husband files for a divorce, decree of divorce grant, ex parte. The wife prefers an application for recalling of the divorce order. Thereafter files an application before the Supreme Court for transfer of the proceedings from courts in Calcutta to courts in Noida. Now, pending that, I file a petition for custody of the minor child. The Supreme Court directs that let there be a stay on the custody petition, whereas the petitioner shall be at liberty to file a application for seeking visitation rights. Visitation rights application filed. The learned judge directs the respondent to be present in person, whereas the respondent she goes before the Supreme Court and seeks further stay of the visitation rights application as well. However, the Supreme Court directs that since the court has the necessary mechanism for conducting court proceedings virtually, let the respondent appear virtually. On the next date, she appears through her advocate, again making an application that liberty be given.
Keep me a minute. You are challenging the order dated 23rd of July
23rd July. That's at page 24.
You are the father.
Yes, Lordship. If your Lordship takes the order.
Please give me a minute.
Yes, Lordship.
So 10th of September, it has been fixed for hearing of the visitation petition.
Yes, Lordship. But the problem is that the respondent, she is repeatedly making effort, she is putting in efforts to stall this proceeding. I am only seeking orders in terms of expeditious disposal of my application. That's my only prayer before your Lordship. Because Lordship, on thrice she's tried to stall this proceeding. Your Lordship will kindly see the order at page Lordship of the Honorable Supreme Court. It records that the court below has that the learned trial judge he has the mechanism for conducting proceedings on virtual mode. Yet she is making another application to appear online.
Yes, so Honorable Supreme Court has permitted them to appear
Yes, so she could have appeared virtually. Instead, on the next
application that could have been allowed. The learned trial judge has rejected 2 prayers, 1 application.
Exactly, my Lordship. If
then what can be done?
Lordship,
you serve a copy. By the order in लिखे दिन, it is however made clear that
For my application for amendment of written statement has been rejected on the ground that it has been made after 3 years. Because in the written statement, I have mentioned that I have become owner by virtue of deed of gift. But at the time of recording, there is a wrongly recorded plot number. That order was passed in 2019, but I made the application in 2023.
where is the application for amendment?
Amendment at page 26, Annex D. Proposed amendment is at page 27.
Yes, paragraph 12F.
Yes.
You sought for deletion. Why?
Paragraph 12, I have stated is at page 22, 23. Second para. Here it is mentioned that at the time of writing of the said deed of gift, it was written by seeing that the said attested porcha of Nita Shikari, hence in the said deed of gift, plot number 755 was wrongly written inadvertently instead of plot 775.
Yes.
That has been corrected by the settlement officer. That's why it is not required.
No, but why do you want to delete that paragraph? Let it remain. What is the difficulty?
Order has been passed. It has been corrected.
What has been corrected?
755 instead of 775 it has been done.
Where it has been corrected?
Settlement officer. I have made an application.
No, that has been corrected. It's well and good. It says that at the time of writing, the said deed of gift was written by seeing the attested porch of. Hence, in the said deed of gift, the plot number was inadvertently recorded as such and such instead of such and such. So you have explained that.
Yes,
so why
yes,
do you want to delete this paragraph?
Kindly come to G. That this defendant has applied before the settlement authority to record his name with reference to the said deed of gift which is under consideration.
Yes.
Order passed, so it is not required.
That is one thing is correction of the record of rights.
Yes.
That is one part. That you want to record that pursuant to that order, your name has been recorded. That's one part. Why do you want to delete paragraph 12F?
It is not required in this case because
It is not required. You are not pressing that.
no.
But that amendment is for twofold grounds. You have sought for amendment of deletion of paragraph 12F also. Please see your amendment application.
Yes. It mentioned that on the basis of the said application of the defendant, the name of
No, that is all right. That is
Yes.
12E, 12F.
12F. Here it is mentioned that at the time of writing of the said deed of
You wanted deletion of that. Why it will be
Yes, it
deleted?
is not required. I am not.
You are not pressing this. Yes.
So, Lordship, for the petitioner, Your Lordship, the petitioner has filed an application under Order 1 Group 10, brackets 2 of the Code of Civil Procedure for being added as a defendant. Lordship, it was filed on
suit for.
The suit was for declaration and permanent injunction.
What is the declaration sought for?
Your Lordship, the issue is, Your Lordship, is that previously another suit was filed before the learned civil judge senior division.
What is the declaration sought for?
The declaration which was sought for was with regards to, Your Lordship, just. From not allowing the defendants or the opposite from disturbing the peaceful possession of the plaintiff. The plaintiff is, Your Lordship, right now not in possession of the property. The possession is with the applicant. I'm the applicant and I'm the leasee. I'm the owner of the leasehold interest, Your Lordship. Previously, one suit was filed wherein I was impeached as a defendant from before.
Maybe that cannot be a ground for your applying under Order 1 Rule 10.
Your Lordship,
what is your locus standi?
My locus standi, Your Lordship, is that I am the owner of the leasehold interest, Your Lordship.
Maybe you are at liberty to file an independent suit.
Your Lordship,
plaintiff being the dominant status can decide.
Lordship, that is already, it has been filed, Your Lordship. It is fixed for hearing on 15th of September, Your Lordship. I'm just paying for expeditious disposal of my application, Your Lordship. We are going
in all suits. You are advising to file Order 1 Rule 10.
Your Lordship, the two suits have been filed. In the first suit which was filed, Your Lordship, the plaintiff and defendants, they are the plaintiff and defendants in this suit as well. They are filing suits against each other and not appearing.
Under Article 227 of the Constitution of India is at the instance of an applicant.
My Lord, I'm for the petition. I'm not pressing this application, my Lord. I'm not pressing this application.
The learned advocate appealing for the petitioner submits that he has instructions. Next.
Number 27.
27, my Lord, it's an application for expeditious hearing, my Lord. Suit is at the PH stage. My Lord, at that stage, my Lord, I have filed an application under Order 39, Rule 7, my Lord. My Lord, next date has been fixed on 18th of November 2025.
When have you filed that application?
My Lord, I have filed my application on 2nd May 2024, order number 18.
You are for the plaintiff.
Plaintiff landlord.
Yes. Your application ought to have been dismissed for default on 24th of September. You did not appear on that date.
No,
the suit ought to have been dismissed for default.
Thereafter, chance was given for filing show cause. Show cause was
Yes,
accepted upon payment of.
No show cause was necessary. Non-appearance on the date fixed for hearing, suit could have been dismissed for default. And you have approached for expeditious hearing.
No, Millard, thereafter show cause has been accepted, Millard. Sufficient cause was given, Millard. Thereafter, upon payment of cost, Millard, show cause was accepted. Twenty-ninth of April.
Written objection has not yet been filed.
Written objection, you are not.
So,
written objection has not been.
What is the next date fixed?
18th of November, Millard. Page
18th of November.
18th of November, page 58.
Even if there is resolution of the bar association, he will appear. I'm recording that.
Your does not record.
Why? This application under article.
Jurisdiction to entertain this.
That can also be decided in an appeal. That can also be decided in an appeal.
Three aspects are there, my lord. First is, my lord, that jurisdiction special limitation period has been expired when I came to know that the complaint has been entertained in the year 2021, my lord. So actually, first time I came to know in September 2024 when already this the shock was in the execution proceedings was there, my lord. So thereafter, my lord, they moved the execution proceeding, and thereafter, actually, if your lordship see, my lord, first order was that to arrest me and put him in a civil imprisonment. Well, can you see page 59? This order I produced by the application that you cannot actually directly jump to this order. You have to, well, page 59. This is the Honorable High Court order. First, issuance of bailable warrants of consumer disposition should be a measure of last resort and only after exhausting the process of attachment under section 25. So I am saying that had you made this attempt, I could have moved anywhere. But now I am absconding, your lordship. I am absconding that to put me in a civil imprisonment. First thing,
what is the order under challenge?
My certified copy is annexed in this. They have both the order at my, this is after page 62, your lordship. This order, they have passed in this execution proceedings. Secondly, my lord, I also annexed this actually Supreme Court judgment before them, and they are saying that this is not applicable before me. But here, my lord, Supreme Court, Honorable Supreme Court, particularly saying that actually section 230 of the Contract Act applicable to the Consumer Court, and so in that aspect, the agent cannot be sued individually without the principal. So I am just an agent which has been sued without making the principal a party there in your lordship. That order is Supreme Court judgment.
Which order you are challenging?
My lord, both this order I am challenging.
Which both this order meaning 6th of March 2023.
First, that is the decree, my lord. That is
that you are challenging.
Yes, that is degree, and my lord, this is.
Are you challenging that, sir?
18/7/2025 order. This order I am challenging.
6th of March 2023. Are you challenging or you are not challenging?
No, I am challenging both the orders.
How can it be after 2 years, more than 2 years?
Well, I came to know in this September when
you came to know?
My lord, that is show cause notice. My lord, I've already annexed this data. I might came to know in the September, my lord, 2024. My lord,
What is the other order which you are challenging?
page 48. Your lordship, page 48. Man, this is first time I came to know, my lord. Kindly see page 48, my lord.
No. What is the other order which you are challenging?
18th, my lord, 18th July 2025.
18th July 2025.
35. This is certified copy is also annexed after page 62, my lord.
After page 62.
After page 62, my lord, first page. This is this
after page 62.
My lord, this is
18th of July.
Yes, my lord. This is 18 July 2025, my lord. For the reason why I am challenging, my lord, that is also annexed with this.
No order has been passed now. Only an estimate has been directed to be
No,
given.
my lord, no, my lord. Hence the prayer for issuing warrant of arrest for civil imprisonment, JDR is allowed. But there is a direction to come.
Where?
No police station is searching me, my lord. I am. So my kindly see page 59, your lordship. Page 59, once your lordship. The judgment of this honorable high court, which they are saying not applicable, my lord. Page 59, which is placed before them. That this.
No, where it has been said that it is not applicable.
No, my this thing that actually prior to that, they should exhaust these remedies of attachment of my property.
No, where is that you have produced this judgment? You have not produced this judgment.
No, it is with the section 47 application. This is the part of the annexure of 47 application I stated. My lord, kindly see from here.
47 application was not decided. Where is that? 47 application was decided. It was not decided here.
Page 52 is there. Man, they are outrightly rejecting it, returned back to me, my lord, which I filed.
Where is the rejection? Sir, where is the order rejecting section 47? It has not been rejected. Show me that section 47 application has been rejected.
That is my data. Actually, thereafter I filed online. In the meantime, I filed online.
After this order has been passed. After this order has been passed. So
yes, my that is my 47 is there. So your lordship, definitely this is there. But my prior to that, even your.
So if you want, I can direct this application to be decided. Section 47.
In the meantime, this warrant of arrest.
No stay.
No, this is, I'm relying upon the judgment.
Decree is operating against you. No stay. No appeal has been preferred.
No, sir. How can I prefer appeal? If your lordship, kindly see the judgment, which I am saying, this is the actually exceeding jurisdiction.
There is a decree is operating against you.
Yes.
You have not preferred any appeal. It's an appealable order. Repeatedly, the Supreme Court is saying, don't interfere under Article 227 against an order passed by the District Forum.
No, my lord, this is the aspect of your lordship is sitting in 227. My lord, I'm definitely saying this is the honorable high court interfered in 227. This judgment, my lord, which I'm actually placing before your lordship.
So Supreme Court is saying no. Supreme Court is saying no. I'm not disturbed by the Supreme Court order.
No, I'm not saying not to disturb that degree. In that regard, not to disturb that degree. But where my fundamental...
Unless the decree is disturbed, where is the question of passing an order of stay? Unless the decree is...
not a decree, I'm not disturbing, I'm not saying, my lord, to stay that decree. I'm saying to stay this warrant till the disposal of this 47.
If the decree is operating against you, please comply with that decree. I will stay.
This warrant is...
Sir, you are not challenging the decree. And you will say, yes, please stay the execution. That cannot be done.
Well, that is not the part of the decree.
Please prefer an appeal. Here, I cannot interfere with
kindly consider, that is, which order I am challenging is not the part of the degree. If your lordship see 18/7/2025, I'm leaving apart that, my lord, I'm not insisting, my lord, to go into the degree. Right or wrong, my lord, giving me a liberty to actually file an appeal. So that is enough, my lord, that appeal will be admitted. But your lordship, that which point I am saying that 18/7/2025, here the tribunal exceeded, which even Supreme Court and even Honorable High Court saying that you don't do this thing. So how can they do this thing directly jumping the provisions of the Code of Civil Procedure Code? So when they are saying, referring to the Code of Civil Procedure, so they must follow the entire procedure. They cannot say we like that, okay, that section and we will go by that. If you are jumping in this in between, that Honorable High Court saying when you are following the civil procedure, you go step by step by this. So this is, I'm only challenging this procedure where they exceeded the jurisdiction and the binding directions of the Honorable Constitutional Court. And my lord giving me a liberty to file appeal that
I'm not giving you anything. I'm not giving you liberty to do anything because you have challenged it here.
So my lord,
You are not paying, you can withdraw this, you can, then I can give you liberty. Keeping this pending here, I cannot give you liberty to go there.
Which to my lord, this my lord saying CO2 or my lord this 47.
You have challenged that order also in this civil division.
Many things I have challenged. If your lordship see the petition, my lord, I will also challenge this order was not passed in the court, my lord. Here the date was fixed on 2/9/25. So subsequently, since I have not, even a prayer is there to allow me to make a recording of the proceedings, my lord. So here I am not going into that. If your lordship saying I will not into that, this is also they can exceed, they can pass any order in the chambers, my lord. I am not saying in that.
Yes.
If your lordship say, my lord, give me permission, I can record.
When is this section 47 application fixed for hearing?
But date is yet not given. Next date is not given. It was fixed on 30th. So still server not showing.
30th, you have filed this?
No, man, it was filed earlier to 30th. It was filed on 7th August. It is affirmed on 7th August 2020.
7th of August?
Yes, ma'am.
That is after this impugned order was passed.
Yes, ma'am. That is why I definitely. Prior to that, if your lordship see that show cause, in that show cause reply, I filed this. They are saying when your lordship has seen that actually reply is filed and it is satisfactory. It is satisfactory, but they have not commented on this aspect. They are saying, okay, the show cause reply is satisfactory, and my lord, this
by the order impugned, the hand over the possession of the flats, nothing will happen.
No, in that regard, if your lordship see the facts, my flat is already sold, your lordship. Much there is a settlement, already money paid.
Refer an appeal, obtain an order of stay. Yes, next.
Item number 29.
Lord, I beg to appear on, my lord, I beg to appear on behalf of the, my lord, opposite party number 1 and 2.
Yes. Opposite 1 and 2.
1 and 2. But this is an appealable order, my lord.
This is an appealable order. Why?
My lord, order passed under Order 39, Rule 1 and 2, valuation 20 lakhs and 2,000 by the Civil Judge Senior Division. My lord, plaintiff is at page page 18, valuation.
None appears for the petitioner at the time of call. No accommodation has been sought for either. The learned advocate appearing for the opposite party submits that that by the order impugned, the application under Order 39, Rule 1 and 2 was disposed of, thereby passing an order of status quo till the disposal of the suit. Such
With
an
some modification. With some modification, the order of status was passed.
Subject to the relaxation as mentioned in the said order. First up, the order impugned being an appellable one, this court is not inclined to entertain the civil revision application. First up, accordingly, the civil revision application stands dismissed. First up, it is however made clear that dismissal of the civil revision application shall not preclude the petitioner from approaching the appropriate forum in accordance with law. Next.
Item number 30.
My lord, this is a revisional application against the order rejecting my application for stay of suit.
For stay of suit?
Yes.
Why do
My
you
lord,
want stay?
There was a consumer case pending regarding the agreement dated 27th March 2004, under which I intend to buy one shop room. After consideration money, substantial amount had been paid. I had not been handed over. I have been handed over the possession, but execution of the deed has not been done. So against that, I preferred a shoot a complaint case before the consumer forum in the year 2023. Subsequently, in the year 2024, the respondent filed a suit for declaration and recovery of possession and injunction. My lord, the subject matter in both these cases is that the applicability or the enforceability of the agreement dated 27th of March 2004. And interestingly, the order which has been challenged here, the stay application has been rejected on the ground that the proceeding before the consumer forum is not.
Give me a minute.
Agreement is at page 28, my lord.
Where is the deficiency of service?
My lord, the execution of the deed has not been executed.
Where is the deficiency in service?
Yes.
What is the relation between you? Is there a developer or
no?
What is the nature of?
He developed. There was a building. I was a tenant. My father was a tenant there.
Yes.
Thereafter, we entered into an
agreement was between the owner and the tenant.
owner not the tenant. I am the son of the tenant. I am the
Agreement
son
was
of the,
between the landowner and the tenant.
no, agreement was between landowner and myself. My father was the tenant. I surrendered under an arrangement, and
So
thereafter
where is the deficiency of service? How a consumer complaint is maintainable?
consumer.
How a consumer complaint is, where is the definition of service? Show me that is falls within the consumer complaint. The Consumer Protection Act din to. Consumer Protection Act.
Facility in connection with banking, financing, insurance, transport, proceedings, supply electricity board, long for housing construction, entertainment, amusement.
Yes.
My lord, they had.
Is it a dispute within the meaning of the Consumer
Yes, they
Protection Act?
they was obligated to construct the house and hand it over to me and get it the same registered. My
Yes,
lord,
but the
they are
suit,
not
but the scope of the suit is a larger one. It has said that declaration that you do not have any right to remain in the possession. So they want delivery of possession. So
my lord,
let both these two things proceed together. Ashun, this application.
I'm for the respondent.
And for the petitioner.
Yes.
Application for there was a caveat.
Application for
Expeditious disposal
of what?
of my appeal, my lord, a miscellaneous appeal arising out of interim order of injunction. I am the plaintiff. I have filed
You are for the opposite party.
I'm for the opposite.
and I have filed my written notes of argument. My arguments are concluded, and his arguments are going on for the last 3 dates. Next date is on 20th for their
20th.
argument.
For that also expeditious hearing.
It's been going on for the last 8 months. And only pay, my lord.
Kindly go to the dates, you'll see that I am not in front of any.
No, I am not
saying that
I've admitted
everything has been completed. There are 2 dates. Dates are missing. For one is adjourned on the prayer of the petitioner.
And
Appeal.
one
And
adjourned on the resolution.
Resolution of local part.
Otherwise, my part is concluded. I have filed my written notes as well. My lord, kindly see
I have
the
also
last
filed.
order.
We are verge of completing the entire thing.
This application under Article 227.
Just get the server copy today. My lord, date is
Yes,
fixed on
please,
6.
please call the next matter. Please communicate the order. Yes.
Item number 32.
Have you please, your lordship, I am for the petitioners, my lord.
Yes.
My-
Wakalatnamata দিয়ে দিন. Please file it in the department.
I will write.
Yes. ফাইলটা দিন.
হ্যাঁ, এটা 2987 করতে গেল।
Yes.
Order 14, Rule 2, Sub-Rule 2. I have, in this connection. Preliminary issue.
Yes.
Maintainability point, I have filed this application, my lord.
What is the point of maintainability?
Ejectment, it is ejectment suit. In West Bengal, it will not be applied. Ejectment.
Yes.
In respect of ejectment, in West Bengal, must not be applicable, but principles might be applicable when.
Not follow. Ejectment, West Bengal, it is not applicable. I cannot follow you.
Ejectment.
Where is your application for under order 40?
You can see the order. Order. Last annexure, by law. You will also see. After may I place the order, my lord? Easement right in connection with easement right.
Easement right, say so.
Lordship, in
You have said
easement right.
ejectment suit, I could not follow.
My lord, easement right,
Yes, where is the plaint?
my lord.
Where is the plaint?
My lord, your lordship can see page number
17.
17, my lord.
Yes, where is your application?
But I am the defendant herein.
Yes.
And my application, your lordship can see page number 51, my lord. And my subject matter is 56, my lord. I place the subject matter, my lord.
No, where is the application under order 14 rule 2? Where is your application?
My application page number 59, my lord.
59.
Lordship. Page number 59. I have filed on 30th September 2024. I have filed this application. It was rejected on 28th April 2025, my lord. 59 for a moment, my lord.
Yes. 59, yes, place the application.
I have placed the I have submitted the application on 30th September. It was heard on 20th April 2025, my lord.
No, what have you stated in the application? I cannot follow you.
My lord.
Nothing has been stated in the application at page 59.
But page number, I have stated everything on page number 56, the petition, my lord.
Page number 56.
56, my lord.
What is
it was started on 51.
56 is the written objection to the injunction.
Written objection of my written. It was
Yes.
started on 51, my lord.
Yes.
Plenty file 135.
Maintainability will be an issue in the suit.
Lordship.
That will be decided. No problem.
My lord,
this application, maintainability will be decided.
In this regard, I have placed the two judgments, my lord.
Yes.
You also can see two judgments. একটু kindly দিয়ে দেবেন। Paragraph number 29, my lord. Year 2025, Calcutta 37, my lord. Paragraph number 29, page number 40, my lord. May I read it, my lord? Paragraph 29, my lord.
Yes.
Mr. Jedmalani is absolutely right in his submission that the Indian Easement Act 1882 is not applicable in West Bengal, even if the Indian Easement Act 1982 has no application in the state of West Bengal. The English common law with regard to easements, which has been applied in our country by the age-old decisions, does apply to this state. This act, in my opinion, is nothing but mere codification of the English common law relating to easements. My another judgments I will place before Lordship. Kindly দিয়ে দেবেন। Paragraph number 12, my lord, where it was specifically paragraph 101, my lord, paragraph number 12.
Yes.
May I read it? Since there was no grant, in this case, the plaintiff did not get any grant from the respondents or opposite parties. There cannot be right of any support for the heart standing on the land. Here, the respondents are not making out any case of the lateral support. The case of easement of necessity was not made out in the plaint or argued in the trial court. There was no issue on the point. Since it has been clearly found that there was no grant, the further conclusions follow that there is no easement of necessity and there is no scope for suspension or revival of the such alleged easements or for the applicability of the principles embodied in section 47, 48, 49 and 51 of the Easement Act. So my respectful submission, the plaintiff who did not get any grant from the dependents or oblique petitioners herein. So the easement right will not be applicable in my view, my lord. So your lordship can state the operation of the order number 20 dated 28th April 2025. It is my humble and respectful submission. Thereafter, yes, thereafter
this application under Article 227 of the Constitution of India.
My lord, all the, my lord, kindly lordship takes up page number 44 once.
Yes.
44.
Yes.
There was a specific direction that the suit would be disposed of in a period of 6 months from the next date.
Yes.
After that, my lord, up to the point of, my lord, kindly, my lord, comes to page number 64.
What is the order impugned?
But the impugned order, my lord, I'm coming just, my lord, just get, my lord, bears with me for, my lord, 1 second. My lord, kindly, my lord, takes up page 64 once.
Page 64, yes. Yes.
Up to this point, my lord, the wife, my lord, participated in, my lord, the argument stage.
Yes.
Page 64. After that, my lord, kindly comes to the next order onwards. My lord, 151 filed for enhancement of alimony pending till light.
Yes.
My lord, against that, my lord, affidavit of asset, my lord, was directed. My lord, already affidavit of asset was filed, my lord, previously once. Another round of affidavit of asset was directed to be filed. Then, my lord, the wife, my lord, filed an application for interrogatories. That was allowed. My lord, as of today, my lord, I am not challenging that order anymore, my lord. Kindly, my lord, kindly, my lord, directs the court below, my lord, to dispose it of.
What?
The suit itself, my lord.
Argument stage.
The application has been disposed of or not?
No, my lord, this is the latest order, my lord. I'll just
30/11/2024.
Alimony application?
That application is pending. 10/9.
That has to be disposed of first.
10/9 date fixed for alimony application.
My lord, kindly, my lord, the enhancement of alimony application is
pending.
That is pending.
Pending.
Yes.
10th of September is the next.
My lord,
Let that be disposed of first.
My lord, 10th of September is the next date.
Yes.
My lord, after that, my lord, 2 dates were, my lord, directed, my lord, to be, my lord, fixed up at once, my lord. One for, my lord, for taking up that application, another, my lord, for argument of the suit itself. Let, my lord, my lord, conjointly these applications be taken up along with the suit.
Why? How conjointly? If it is enhanced, you have to pay that.
We have paid
Thereafter,
already, my lord, enhanced rate is being paid. Initially 11,000, my lord, fixed by your lordship. After that, my lord, again they filed another application for enhancement. It was, my lord, 16,000 was made. That is
this
being paid.
application under Article 227 of the Constitution of India is at the instance of you are the husband.
The husband
is at the instance of the husband and is directed against an order being number 61 dated 2nd of May 2025 passed by the learned additional district judge, Third Court, Alipur.
Third Court, Alipur.
Fast track.
Learned additional district judge, 7th Court.
7th Court.
My lord, right now, my lord, the matter is pending, my lord, before the fast track court, third court, fast track, third court.
When it has been transferred?
I'll just, my lord.
An order of 2nd of May.
Yes, after that, my lord, transferred. A letter was, my lord, written to the learned district judge. After that, my lord, it was transferred to Omoto.
Third matter, 7th Court at Alipur. Mr. Banerjee, learned advocate, appearing for the petitioner, submits that after the impugned order was passed, after the aforesaid order was passed, this matrimonial suit has been transferred to the court of. Acha, in matrimonial suit number ta bolechi? Passed by the in matrimonial suit number bolini na, ota likhe din to. In matrimonial suit number 3142 of 2018. ঠিক আছে? Therefore, after the said order was passed, transferred to the learned additional district judge, fast track court.
Third fast track court.
Learned additional district judge, fast track court, third court. At Alipur.
At Alipur.
At Alipur. Full stop. Paragraph. After some argument, Mr. Banerjee, learned advocate, appearing for the petitioner, submits that a direction be passed upon the learned trial judge to dispose of the matrimonial suit and the application for enhancement of alimony, which is still pending. First, Mr. Banerjee submits that the application for enhancement of alimony is fixed for hearing on 10th of September 2025. Stop. In view of the order sought and proposed.
And my lord, for 15th is, my lord, for argument of the match suit.
15th of September.
15th of,
and 15th of.
My lord, kindly comes to, my lord, page 83.
And 15th of September 2025 has been fixed for argument in the matrimonial suit. In view of the order sought and proposed to be passed, there is no necessity of direct issuance of any notice upon the opposite party. However, the learned advocate on record of the petition shall be obliged to forward a copy of this application along with this order upon the opposite party or the learned advocates representing the opposite party before the learned trial judge. So in the light of the submissions made by Mr. Banerjee, learned advocate for the petitioner, your number section stands disposed of without interfering with the order impugned, but by requesting the learned additional district judge, first track court, third court, first track court, third court, you have struck off in the cost title. You are saying it has been transferred. I do not.
My lord, kindly, my lord, comes to page 83 once. 83. 83, my lord, is the certified copy of the order, my lord, 16th of July.
But why have you struck off that in the cost title? The learned additional district judge, first track court, third court at Alipur to take up consequences will follow. Yes.
The plaintiff is the petitioner. Plaintiff decree holder is the petitioner before your lordship. Suit filed for eviction. Initially decreed, my lord, on all the grounds, all reasonable requirement and the my lord, lock and key. Thereafter, my lord, the appeal court modified and restricted it to the my lord, the lock and key. The suit property is being made lock and key by the defendant, and he has an alternative accommodation already. So, my lord, ultimately decree, my lord, of eviction affirmed by the appellate court also. Decree put into execution, execution done. At the time of execution, my lord, the handing over possession, the inventory was made. There are several articles, as many as 26, I think. 29 numbers of articles were, my lord, kept by the judgment debtor, and my lord, the Jimmanama was prepared. I filed an application before the Bidhan Nagar court, before the executing court, that look, these are there. So kindly direct all these articles to be put on the Nazarat department of the concerned court. The court stated by the order that the Bidhan Nagar court do not have the Nazarat department. It has to be done by the Barashat court. Lord, that is the order, my lord, before your lordship. Kindly takes up, my lord, order dated 4th of September 2023. It's the bunch of certified copy of the execution case. I want to draw your lordship's attention to the 4th of September. It's pursuant to an application filed by my client. That is, my lord, at page 51, the application of mine.
No, the judgment debtor was, a notice was directed to be issued to the judgment debtor.
Judgment debtor by the Barasha. Your lordship, kindly read on, the operating portion your lordship will find, my lord. This exercise was directed to be done.
Thane district judge 24 Parganas not at Barasat.
Yes, yes.
So what is the difficulty?
Now, my lord, no. Thereafter, page 54, this was communicated, my lord, by the Bidhan Nagar court to, my lord, the Barasha. Thereafter, nothing is being happened. Lord, it's a old man who has got the property but could not able to enjoy the entirety of the, my lord, tenanted portion
is being occupied by so many of articles.
Page 54.
54, my lord, is the memorandum by virtue of which the internal communication is being made, my lord, from Bidhannagar to Barasat. But
Yes.
thereafter, nothing is being happened.
What order you are seeking here? What can be done?
Well, under Article 227, your law. Well, I
What
can
can be done?
even mention before the district judge. District judge is saying that nothing is on record before me. I cannot take any decision. Well, this is something, well, which Bidhannagar Court by explicit language stated what has to be done by the Nazarat department of the Barasat. But the old man is not getting that, and day after day the property is being damaged. Well, this person, health. Well, he was a director of the Department of Health, Government of West Bengal, and the articles are, well, the oxygen cylinders and other things.
The judgment debtor.
Yes, I know, Milord. I have stated the present residence.
How cylinders can be kept?
He was using, Milord, these premises for, Milord, his personal, Milord, chamber practice. This cannot even, Milord, today we are not here, Milord, to say all these things. But thing remains, Milord, if he do not want to take back these articles, let that be done by the Nazarat department and whatever auction they want to do.
Dated September 4, 2023, the Civil Judge Junior Division Bidhannagar passed an order directing the clerk in charge of the Nazarat department in the court of the Learned District Judge 24 Parganas North at Barasat to issue a notice upon the judgment debtor, calling upon him to take delivery of the 29 movable articles found and recovered from the decretal property at the time of execution of the decree. And in default, those articles shall be sold in public auction at his risk, and the proceeds shall be applied for meeting all legitimate expenses for sale, and the balance, if any, will be refunded to the judgment debtor. Mr. Mukherjee, learned advocate, appearing for the petitioner, submits that the learned district judge submits that a direction be passed. But this notice was issued, no?
Yes, page 54.
No, this notice was issued by whom?
This is by, Milord, this memorandum
This
is
was communicated.
Thereafter, nothing happened.
Mr. Mukherjee, the learned advocate, appearing for the petitioner, submits that the learned district judge 24 Parganas North at Barasat did not take any steps in terms of the direction the district judge cannot take any steps. The clerk did not.
Concerned department. That's why, Milord, I
submits that the concerned department of the learned district judge 24 Parganas North at Barasat did not take any steps in terms of the direction passed by the learned executing court. Mr. Petitioner is directed to serve a copy of this application by registered speed post with acknowledgement due upon the opposite party and file an affidavit of service on the next date. List this matter under the heading motion in the monthly list of November 2025.
That's to be mentioned, Milord. It's 2013 decree. Today we are in 2025. This man will go. He will pass away. He will not be even able to see, Milord, what enjoy his room. It's for reasonable requirement.
To be mentioned, monthly list to be mentioned on 17th of September 2025.
I'm ready.
Yes, next.
I'm for the petitioner. This application for expeditious disposal. The application was filed. The petition is a husband, my lord. The application was filed under section 25 guardians on all, along with the section 6 into minority act, my lord. My lord, it's innocuous where we will lordship kindly dispose of the interim visitor application prior to puja vacation. Kindly, my lord, see the order number 7 and 8.
Application for visitation right is pending.
Pending, my lord, last 2 years.
Application under Article 227 of the Constitution of India is, who are you?
Father.
You are the father.
Father, my
lord. Is that the instance of the father paying for a direction upon the Learned Additional District Judge, First Track Court, Fourth Court at Barrackpur to dispose of the application for visitation right filed in Act 8, Roman VIII. Filed in Act 8, VIII, yeah. Case number 43 of 2024, expeditiously. First of the learned advocate appealing for the petitioner submits that the hearing of the application for visitation right has been fixed on
Fixed on, my lord, January 3rd, 2026.
3rd January 2026. He further submits that the application is otherwise on this call.
It's
Monthly fixed matters are there, Mr. Punik.
Your Lordship, Friday, Your Lordship.
Yes, it will be taken up, please. Some fixed matters are there in the monthlies. Yes, call the list.
Item number, password টা করবে?
Password, call code. Yes.
Item number 21.
21, yes.
Your Lordship, I am appearing on behalf of the opposite party.
My lord, I am appearing for the petitioner, my lord. It's my application, my lord.
You are paying for?
My lord, this is 7-2, my lord, and that there has been
application.
7-2 application.
Regarding the Supreme Court order that condonation of delay is not applicable. Well, there is an order of Calcutta, I would say, inquired from the lower court advocate, passed in the 7-2 application, which came up for revision application. Well, I just want to go to that order and place that order. I don't have that order right now, my lord. Well, can we keep it day after tomorrow, my lord?
No, for what? What is the order passed?
Passed, the learned lower court advocate informed me that there is an order passed by this honorable court. By this honorable
No, what is the impugned order? I am coming to that. Please kindly come to the impugned order.
Yes, sir. Impugned order is at page.
Numbering থাকে না, numbering থাকে না.
Recognition, madam, I'm very sorry, madam. The certified copy.
Certified copy
is
আসলে numbering
there.
থাকে না, numbering
Certified copy is the next.
after page number 85, Your Lordship.
Yes. 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 At the stage of argument, how can you file an application under section 7.2?
My lord, that application was filed, and my lord, I'm told, my lord, by the lower court advocate that there was some order passed by this honorable high court. That is why that 7-2 application was heard by the lower court. My lord, I don't have the copy of that order. I've told him, my lord, he's giving me today, my lord. My lord, keep it day after tomorrow, my lord. If I can satisfy, my lord, fine, my lord. Otherwise, my lord, I'll face the consequences. I just wanted that accommodation, my lord.
No, you filed the application on 17th of September 2018.
After 7 years.
Yes, you appeared in 2011. Maybe the High Court directed to reconsider. That's a different thing altogether.
But I don't have the copy of that order. If I can catch, if my lord, can you keep this matter day after tomorrow at the top, my lord? In the meantime, I'll catch hold of that order, my lord, and place it if it is relevant, my lord. That is the only prayer, my lord. I'm just seeking accommodation, my lord.
What is the stage of the suit?
Evidence is in the stage of evidence, Your Lordship.
I'm not asking for right, my lord. Just keep it for day after tomorrow, my lord.
proceedings.
Uh, the learned advocate appearing for the petitioner submits
Item number 333.
none appears for the petitioner at that. No, this matter was mentioned citing urgency, considering the urgency pleaded. This matter was fixed. However, when this matter is taken up for hearing, none appears for the petitioner. No accommodation has been sought for either in view thereof. CO 100 of 20.
Four 71 ডাকা হয়েছে
71.
471 my lord, I appear for the petitioner.
Yes.
It is a matter for expeditious disposal, my lord, of a Act 8 case, my lord, where the father has applied for guardianship of the minor, my lord.
What is the stage of the proceeding?
My lord, applications are being continued. My lord, the initial an application was taken out for visitation by me, my lord, being the grandparents. My lord, that was allowed an application for modification of visitation. And thereafter, my lord, I had filed an
application under Article 227 of the Constitution. 475. Yes, Mr. Haldar.
Madam, beg to appear for the opposite party in this matter. At the threshold, I should apologize, my lord, for not being physically present.
No.
I was in court, but due to certain medical exigency, I had to come back.
No problem. You can appear virtually.
My lord, obliging.
No problem. Yes. Call the next.
Plaintiff is the petitioner before your lordship. Suit for declaration and permanent injunction. My lord, I have purchased, my lord, some portions of the suit property and the remaining portion of will by virtue of probate, but that is I also filed my lord application for revocation of the said probate that is pending for consideration. Now my lord,
what is the suit for?
Suit for declaration and permanent injunction. Now my lord, the problem is my lord, there is a
what is the declaration sought for?
Declaration sought for, my lord, that the plaintiff has right to enjoy the property. Defendants have no legal right to make any illegal construction by which the life and family members of the plaintiff will be in danger. Permanent injunction.
All right. Yes. What happened?
My lord, there is
what is the impugned order?
But there is a pump room in the, my lord, at the ground floor, my lord. My lord, from the said pump room, my lord, the water is, my lord, allocated in the ground floor reservoir. Therefore, it is lifted to the overhead. I am residing in the second floor. The defendant is occupying, my lord, in the ground floor. And there is a, my lord, tap water which is directly connected with the ground floor reservoir. So far, my lord,
there is
a tap, my lord.
Yes.
Attached to the ground floor reservoir.
Yes.
So far, my lord.
Stopcock or tap?
Tap.
Yes.
So, my lord, there is no, my lord, problem of, my lord, supply of water so far as the ground floor is concerned.
Yes.
Now, my lord, the pump, my lord, got defunct. My lord, the defendant, my lord, put a padlock in the said pump room. I took out an application for, my lord, opening the said, my lord, the pump room, my lord. So my lord, the pump can be, my lord, repaired. My lord, court has allowed, but in a very peculiar manner, my lord. I was not allowed to enter into the, my lord, said pump room. If your lordship kindly turn to the, my lord, operative part of the impugned order. If you also kindly turn to, prior to that, my prayer, my lord, in the application, my lord, at page 32. Page 32, my lord, onwards.
Yes.
The paragraph 3, my lord, page 31, the plaintiff is occupying the second floor of the premises and defendant number 1 is occupying the ground floor. Page 32, my lord, paragraph 4, that on the ground floor, there is a water reservoir where corporation water flows through pipeline and it is stored on the reservoir and the said water by way of an electric pump, whereby the water from the ground floor reservoir is being stored on the rooftop reservoir, from where through the pipeline it enter into the plaintiff's occupied portion. Defendant also do get water through electric pump, but since the defendant number 1 occupies the ground floor, there is a direct supply of water to her portion through a pipeline attached to the ground floor reservoir. Then there is no stoppage of water in the defendant's portion in the premises. That on 3rd December 2022, the aforesaid electric pump went out order, and as such the plaintiff do not having supply of water through the pipeline from the electric pump in the premises. The defendant is ready enjoying the water since there is direct supply water through the pipeline attached to the reservoir. That the electric pump is installed in a room which is used as a pump room. It is to be mentioned here that the electric consumption of the electric pump is being paid by the plaintiff. The defendant intentionally and by force has put a padlock on the door of the pump room. The plaintiff is repeatedly requested the defendant to open the padlock so that the plaintiff may repair the room and have the pump repaired. That the defendant did not bother to open the padlock. The other told the plaintiff that shall not allow the plaintiff to repair the electric pump room, nor shall allow to enter the pump room. The plaintiff, along with his family members, are passing their days with great difficulty. That the finding no other alternative, the plaintiff lodged a written complaint before the local police station, but the police authorities are reluctant to take any action in the aforesaid facts and circumstances. Necessary order be passed by the learned court by an ad interim order of mandatory injunction, directing the defendant to give access to the plaintiff in the pump room for repairing the pump immediately, for installing water on the reservoir at the roof of the premises, for supply of water in the plaintiff's portion in the premises. Then my fair portion for issuing an order of mandatory injunction, directing the defendant 1 and 2 to reopen the padlock so installed by them in the pump room for necessary repair the electric pump at premises number 6Y/1A and 6Y/1B, Umakanto Sen Lane, within a reasonable date from failing which the plaintiff will be at liberty to break open the padlock and enter the pump room in the premises for necessary repair, cost of which is to be borne by both the parties.
Cost of which?
Is to be borne by both the parties.
Yes.
Then, my lord, kindly turns to my lord page 37.
What is 37?
Page 37, my lord.
What is that?
My lord, the water line, my lord, stands in the name of the present petitioner Nirmal Kumar Datta. Nirmal Kumar Datta in the upper portion, my lord. Place of water supply 16 by 16Y by 1B Umakanta Sen Lane.
Name is not appearing.
Nirmal Kumar Datta.
Oh, yes, yes.
He is the petitioner before your lordship. My lord, the water supply stands in the name of the petitioner here. Learned court below was pleased to my lord allow, my lord, if you will also kindly turn to my lord, page my lord 52. Page 42, paragraph 7.
Yes.
Suddenly, on 3rd December 2022, the water pump which is located at the ground floor was not working. As such, I, along with my daughter, went to inspect the pump room and found that the said accused person.
Yes, Mr. Jha.
My lord, this case has a checkered history. May I, before your lordship puts in the question, I should be very candid on the issue concerned. Your lordship, the last document which my learned friend has referred to is the document issued by the corporation, whereby it is issued in the name of the petitioner Nirmal Kumar Datta, and the address is 6 by Y by 1B.
Yes.
The water supply has to be effectuated to 6 by Y 1B, but the pump room that they are asking to be opened, that is situated in 6Y by 1A. And by virtue of this application, they are trying to take possession of that room. And for that reason, precisely, the learned court has passed an order, thereby directing that the repairs should be effectuated, costs should be borne, but the room was not handed over to the plaintiff because of the reasons that on the second floor of this portion 6 by 1A, the petitioner has already encroached. There are a number of litigations pending.
Only one thing. You are
Right.
also you will also be benefit. Now the pump is in a defunct condition.
That pump is in defunct condition for the last 10 years.
Yes, yes. So now if the pump is repaired, you will also be benefited.
I have not, I could have challenged this order. I did not, because I wanted the petitioner to bear the money. They did not pay the money. They did not put in the money.
No, they will, Mr. Jha, there are two things. If this pump is repaired, you will also be benefited with the.
But one thing, I don't stand in that way, but one thing has to be ensured that the petitioner shall not get the custody, or rather the any key to that particular pump room, because that property, this is the entire trend of encroaching upon my property.
Mr. Jha, only one thing, you will allow the mechanic, he will appoint a mechanic, or if you appoint a
I will appoint. I'll personally take that responsibility, my lord.
Then you have to bear the cost. Then you have to bear the cost. You can appoint, keys will be with you, you open, you repair, I give you time.
My lord, can I make one submission, my lord?
Mr. Jha, if he has to bear the expenses, he will appoint the mechanic, not you. Or you.
I leave it to your lordship. I leave it to your lordship.
Bear the cost, you need not give him the keys also.
This premises, my lord, kindly appreciates one aspect, that the premises for which the water is being asked for is 6 by Y by 1B.
All right, no problem, Mr.
They will not make an application for a separate ferule.
No.
Title 2.
Mr. Jha.
But the pump room is situated in my portion.
Yes. So only repairing. If you want, you repair. I'm not. But then if you appoint a mechanic, Mr. Jha, there are two things. If he appoints.
Connection got interrupted, my lord.
If you appoint the mechanic, you will have to bear the cost.
One thing, my lord.
I'm extremely sorry, my lord. I got disconnected due to the internet issue.
Or you can do one thing.
My lord.
The padlock, he will find out mechanic, he will do that repairing. So possession, nothing, only he will make that repairing with his mechanic, and then you will have your padlock, you can open that. And if you want a special officer for that purpose, that also can be done, but at your cost.
I am a poor lady, a widow.
That is why
unable to enjoy my portion of the property. Gradually, they are infringing upon my property. And with this particular application, which is actually a frivolous application,
yes,
my lord, because I am not going into the checkered history of this particular property.
It's only with regard to a pump which is there. The
I reside at the second floor, my first floor. I have to take water to the first floor myself.
That is why, Mr. Jha, I am telling you, it will benefit you also.
I should not say what happens with this particular property. The bathroom is situated on the first floor. The moment these people won't see that I want to go to the bathroom, they go inside and lock the door. This is the story behind everything.
That is a different thing. Now we are on the pump, so let it be repaired.
Supply of water will create trouble, because each one, I am also bearing for the water. They are also bearing for the water. This pump room is in my portion. The property is separate property. For years, they have not taken any steps to get a ferule for their particular property. They show a bill for 6Y by 1B. Let them take water from 6Y by 1B.
One thing, my lord.
No, the property is different.
No, my lord.
Yes, my lord.
Can you come to page 28?
My property is 6Y by 1A.
Page 28. Page 28, my lord, just 2 lines from the top.
Yes.
This is the written statement filed by the opposite party hearing, that with regards to the statement under the allegation contained in paragraph 5 of the amended plaint, the answering defendants deny the same and submit that they are co-owners of the suit property and staircase, roof, pump room are common.
Yes, pump room is common, Mr. Jha. You have admitted.
Statement.
That is a wrong statement, my lord.
In the written statement,
my lord, kindly, can I request one thing, my lord? Kindly takes up the matter tomorrow. I'll be physically present and I'll show documents to your lordship.
You have said
in one day, my lord, things will not go hayward, my lord. Kindly appreciates that, my lord.
Nothing will happen. You open the padlock, you will appoint a mechanic, he will bear the expenses, that will be repaired. When you will appoint a mechanic?
Then the date and time has to be specific, my lord. Because I'll be harassed by virtue of this order. I'll be harassed throughout, my lord.
Thursday, my lord.
This Thursday?
Yes, sir.
Since, give me the time.
And I should be candid. Another thing I should inform to your lordship.
Yes.
This entire proceedings is a fraud upon the court, because the person who is giving the instruction, is, and he's a tenant of that particular property, not the defendant, not the petitioner. And he has, your lordship asked for the Aadhaar card, which he'll show.
Who is standing behind you? Is he the co-owner of the property?
No, my lord.
Person who
He's
is
playing foul, my lord.
Is he the co-owner of the property?
He's a neighbor of the. He's a neighbor. My Nirmal Lord is very aged one. He's a very aged one, my lord. He's aged about, my lord, 70. He's totally bedridden, about 80 years old.
So how can he say without taking instructions? This shows he's in control of the entire thing.
Your lordship asked for the Aadhaar card. It shows address 6Y.
Thing, Mr. Haldar.
The property 6Y was erstwhile. After partition, it has become 6Y by 1A, 6Y by 1B.
Yes, Mr. Jha, please give me. What is the stage of the suit, and since when this pump is lying defunct?
Next date for issue, my lord.
Since when the pump is lying defunct?
He has given a date of 22, but for the last 10 years, it is defunct, my lord.
I have lost complaint before the, my lord, December 22.
Yes.
Yes, I took out an application immediately.
Yes.
This was disposed of, my lord, in 2005.
But he is saying that his pump is lying defunct for the last 10 years.
That is not, that,
where is his written objection? Show me.
Yes, my lord,
that he has said that it's...
that effect. No. They are written objection page 44, my lord.
44, yes. Yes, Mr. Haldar, do it in a Saturday. I will appoint learned advocates on record of both the sides as special officers without any remuneration.
My lord, that I am with your lordship.
It will be in your custody. The mechanic will be there for repairing. After repairing, the keys will be handed over to Mr. Jha's client.
I'll be present there, so I'll be taking care of that part, your lordship.
Convenience of both of you, both the learned advocates on record of both the sides will be appointed. No necessity to pay any remuneration. Saturday and Sunday. Convenient to both of you? Please tell me.
It will be around 4:30 in the evening, my lord, on Saturday.
4:30 in the evening may be a difficulty because mechanic will have to. It will be difficult for a mechanic to. It has to be in the daytime. That is why I've said Saturday or Sunday. It can be on a Sunday. Mechanic you will get. Better on Saturday.
My lord, in the morning.
Saturday. This Saturday, I am appointing the advocate on records of both the sides. Key he will open, and the mechanic will do the repairing work. After that, he will put in the keys. Both of you.
But I tell you, lordship, this I am agreeing to the proposition, but this will cause harassment for me entirely thereafter. Thereafter, a series of harassment I have to face.
And to both the sides because this is a common room. That is the state. That is the
how can a property which is.
Show me your prayer. Show me your prayer.
What it is, there is a.
Can I indicate one thing, my lord?
Mr. Haldar.
Page 34, my lord.
Page
34.
No, your prayer is to break open only for the purpose of entering into the room for repairs, only for that limited purpose.
That's super. This is a palm room. Then
prayer,
again, my lord,
they wanted to capture that room and enforce upon that room.
That is so, Mr. Haldar. It's an appellable order, mandatory injunction.
My lord.
227.
I did not make that submission, but this is actually the real provision.
Those complications go before prefer an appeal. Thank you. This application under Article 227 of the Constitution of India is at the instance of the plaintiff and is directed against an order being number 45 dated December 18, 2024, passed by the Learned Civil Judge, Junior Division, First Court at Shialda, in title suit number 148 of 2017. So, by the order impugned, the prayer for mandatory injunction.
No, I am not paying. So far as repair this concern, kindly do this, my lord. So far as the repair of this concern on Saturday or Sunday, my lord, kindly finish it. I am suffering, my lord. Kindly finish it. He will not be prejudiced in any way, my lord. He would also, my lord, get supply of water.
Please hear the order, Mr. Haldar. The prayer for mandatory injunction was allowed with the condition that the plaintiff shall not be allowed to enter into the pump room, but he will provide the necessary monetary funding needed for the repairs of the pump. Full stop. Mr. Haldar, learned advocate appearing for the petitioner, submits that the pump is lying in a defunct condition. Full stop. He further submits that the petitioner is residing in the second floor or the first floor?
Second floor.
In the second floor.
Which address? My lord, kindly ask the address.
Is residing in the second floor of the building in question, and it is difficult for the petitioner to carry the water from the underground reservoir to the second floor flat of the petitioner. First paragraph. Mr. Jha, learned advocate appearing, he submits that the learned trial judge allowed the prayer of the learned trial judge only allowed the petitioner to provide the necessary funds for repairing, but did not allow the petitioner to enter into the pump room. First paragraph. Mr. Jha, learned advocate appearing for the opposite party, submits that the pump room, that the petitioner, that the opposite party is in exclusive possession of the pump room. First stop, he submits that the petitioner herein do not have any manner of right in respect of the pump room. First stop, he further submits that the pump is lying in a defunct condition for more than 10 years. So such submission is disputed by paragraph D. Such submission is, however, disputed by the learned advocate for the petitioner. First of all, he submits that the petitioner and the opposite parties are co-owners of the property, including the pump room, as would be evident from the averments made in the additional written statement. First of all, he submits that the pump is lying in a defunct state only from December 2022, and immediately thereafter he filed an application for mandatory injunction. First of all, heard the learned advocates for the parties and perused the.
One thing, instead of repairing, let the new pump is to be installed at my cost. Otherwise, it would create much problem. Then it will not be repaired by within.
All right, Mr. Jha, he wants to put a.
Let there be a new pump. But provided there are two things, my lord, I'll pray.
Yes.
Number one is the gentleman who is standing there, he should not be there in the premises to create disturbance. That should be there, my lord, because he is the main culprit. And second is that the water that will be supplied to my portion on the upper floors, that will not be disrupted by the plaintiff, by the petitioner. Because that is their nature, which they are continuously doing by harassing this lady.
For the
I'm
party,
doing this matter pro bono, my lord. I should be clear.
আচ্ছা ওই যেখানে মিস্টার হালদারের সাবমিশনটা বললাম না সেখানে একটা বলুন যে Mr. Haldar further submits that since the pump is an old pump, it may be difficult to repair the same and to make it functional. First up, he submits that the petitioner be permitted to install a new pump in place of the old pump.
That will not create any right.
Yes. যেখানে মিস্টার ঝা সাবমিশনটা করে দিলাম সেখানে একটা রেকর্ড করুন মিস্টার ঝা ফার্দার সাবমিটস দ্যাট ইন কেস দি old pump is made functional or the petitioner is allowed to install a new pump, the water supply to the portions to other portions of the property should not be affected. Full stop, paragraph. Heard the learned advocates for the parties and perused the materials placed. Since it is not in dispute, it is not in dispute that the pump is not in a functional state. Full stop. Mr. Haldar would contend that the pump is not functioning from 2022, whereas Mr. Jha submits that the same is not functioning for more than 10 years. First up, in view thereof, this court is of the considered view that instead of repairing the old pump, the petitioner may be permitted to install a new pump at his own cost. First up, paragraph, after hearing the learned advocates for the respective parties, it appears to this court that there are serious disputes between the parties with regard to supply of water as well as right, title and interest in respect of the property in question. In order to avoid any further controversies as well as any further controversies at the time of installation of the new pump, this court feels that the special officer should be appointed to supervise the installation of the pump. First up, then the date and time may also be fixed, or I am fixing.
My lord, let them purchase it. And Saturday or Sunday, whatever is convenient. And one thing, your lordship, if I appoint any junior, that junior can be there, my lord. That liberty should be given.
Petitioner will be at
liberty. If installation will take the entire day, we'll be missing our chambers.
Install a new pump at his own cost at the pump room, and for such purpose, the opposite party shall open the padlock and allow the mechanic of the petitioner to install the same and to install the same for the purpose of ensuring smooth supply of water to the entire premises. Full stop. The learned advocates on record of both the sides are appointed as joint special officers to supervise the work of installation of the pump. Full stop. The work of installation of the pump shall be carried on any Saturday as may be mutually agreed upon by the joint special officers.
Kindly fix here and now, madam. Otherwise, it would be difficulty. Kindly fix here and now.
Your lordship will fix the time. They'll not turn up and then raise a complaint that I did not cooperate.
Coming Saturday
between,
between 10 a.m. to 5 p.m.
The entire day will be missing our chamber, my lord.
The work of installation cannot be completed. The work of installation as well as smooth supply of water to the premises cannot be ensured on one day. The same shall be continued on the next day, that is on Sunday, date gulo the other one, in the presence of the joint special officers. Full stop.
Or their appointed juniors, my lord, or agents. Because entire day, if I have to stand there, then I'll be missing the work.
Advocates on record or their juniors.
My lord.
Appointed as joint special officers. Full stop. The petitioner, the parties may also be present at the time of such repairing work, but the special officers shall ensure that none of the parties create any obstruction in the work of installation of the pump. First of it is, however, made clear that installation of the pump shall not create any equity in favor of the petitioner.
Much obliged, your lordship.
Disposed of with the aforesaid observations and directions. Yes, call the next matter.
As the date, the time is concerned, my lord, let it be fixed. But otherwise, it would.
Sorry, next Saturday and Sunday. Mention. Date gulo mention kore. Coming Saturday, Sunday, or the next Saturday, Sunday? Which one?
This Saturday, Sunday.
You will purchase everything, mechanics. They are in your control. That person's control.
No, the person standing at the back, his control.
I am asking you.
And if they fail, if they fail, my lord, then again they have to approach the court for the for further directions, my lord.
Special officers, Mr. Jha, that is why these special officers I have appointed. They have to supervise, to control the situation, everything.
Oblige, your lordship.
Yes, call the next matter.
Item number 700.
So this is the matter relating to the custody of child.
Custody?
Temporary custody. I have challenged the order of
visitation
and temporary custody.
What do you mean by temporary custody? We'll take the child, keep him for some day, then return.
Yes.
When did you last meet your child, Mr. De?
Last. Well, it kindly come to the order passed on 26th.
Yes, I'm asking you, when did you last meet your child?
Thereafter, madam, in the month of October 2024.
What is the age of your child?
14.
Son or daughter?
Daughter, 14. I am the mother. Yes, I am the mother.
Wait for 4 years.
My lord, I'm just coming.
Wait for 4 more years.
I'm giving you the facts, my lord. The petitioner filed an application, section 25.
But Mr. De, how can this be decided in the absence
kindly
of the
come
other
to
side?
the impugned order. If your lordship kindly come to the order dated 26th September.
No, the other side is here. Where is the other side?
You was notified, my lord. My lord advocate.
Prior to mentioning.
My lord, this is the notice, my lord, I've given.
Prior to upgradation.
After that, my lord. After that, my lord. After the upgradation. It's notified that matter is running as item number such and such. But the opposite party, my lord, was in custody. He is charged under section 304B. During the subsistence of the marriage.
It's difficult. Ex parte, it's difficult.
But kindly fix a date, my lord, so that we could.
The learned advocate for the petition.
Item number 1397.
None appears for the
Item number 352.
What is this, Mr. Mitro? That occupation charges. During occupation charges.
Occupation, yes.
You were saying that they are enjoying a large
Yes.
mall without paying anything.
Anything.
Yes.
Lordship, I said, my lord, for the time being, my lord, before my lord going into anything, my lord, they should pay the admitted amount.
Yes, yes. I think he was directed to take instructions. Yes. What is your instruction?
Lordship, by the sir, letter on 13th August
Stay,
that
what's it?
we have
আওয়াজটা এরকম হচ্ছে কেন? Yes. 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 Yes.
Lordship, by their own admission, they have served upon us a letter dated 13th August, whereby they have admitted that that we have paid them 14 crores 16 lakhs from April 2020.
No, so during the period which they have claimed, is anything due or nothing is due?
Lordship, on the last occasion, on the last occasion, Lordship was pleased to observe that this termination was done during COVID. Lordship was pleased to ask.
Please distance. Yes. Please keep some maintain some distance with the mic so that otherwise. Yes.
Lordship was pleased to ask me what was the amount that was paid post the COVID period, that is from April 2022.
Yes.
Lordship, so I have obtained instructions
Yes.
with regards to that.
Have you shared that copy with Mr. Mitro?
I have,
What is-
I have,
Yes.
my lord.
What is the amount which you have paid?
এটা দেবেন তো
2022 থেকে
Lordship, we have paid 9 crore 4 lakh.
So what is the rental amount per month?
We are
26 lakh 50.
26 lakhs 50, my lord.
You have paid. Mr.
26
Mitro,
lakh
they have
50 we are
paid,
paying
they are saying.
every month.
Let them conclude.
Yes, yes. 20 from 2022 you are paying.
This is till July, my lord. July 2025. We are paying 26 lakhs 50,000 every month.
Yes. How have you paid?
Lordship.
What mode?
Lordship, we have paid through bank transfer. They were returning us the amount by checks. The checks were never encashed by us.
So according to you, that amount is still lying in their bank account.
Amount is still lying, and that is by their own admission. From if Lordship calculates from April 2020, which is their letter from, it is coming almost the same sum or something. Lordship.
Yes.
It is coming to that.
Yes.
এটার আর কপি নেই আমি দিয়েছিলাম
Oh, so according to you, it is their admission that you have deposited 14 crores.
It is their admission, Lordship. I am going to submit instruction that this is the that has been submitted. We are tendering 6 lakhs 50,000. We are returning that by a check.
You have not encashed.
Just encashed.
Yes. Yes, Mr. Mitro.
Kindly take the petition once.
Yes.
Kindly take the petition.
No, this amount is not disputed. This amount which they have paid.
The amount they have paid is not disputed, 14 crores.
14
I proceed
crores.
on that basis. The dues, my lord, as on date would be, my lord, about 23 crores. What they do,
23 is over and above 14 or
no,
balance is.
total. 8, 9, 9, approximately 9 crores.
So why this difference?
I'll tell your lordship, what they do not say, unfortunately, is the lease deed provided that, my lord, lease rent would be, my lord, at a particular rate from a particular period to particular
Enhancement.
Yes. Those are not taken into consideration.
Enhancement
Number one,
from which period?
from, my lord, 1st July 2022.
Oh, from 1st July 2022, it will be
rupees 30,47,500.
30,47,000.
And then from 1st of July 2025, it would be 35 lakhs.
1st of July 2025 is just now it has
Yes,
started.
very well, 1 month.
1 month. So, yes, what do you say?
And the chart which has been, kindly look into the chart which has been handed over to your lordship.
Yes. Yes.
My lord, does it start from 2022?
Yes, April.
The dues are from, my lord, April 2020.
Yes.
Kindly look
No.
into.
Yes, Mr. Mitro, but I asked him to show post-COVID from March, April. I've told them.
Kindly look into the order. Well, lord, let us.
Lordship, the order records 2020. I have also
Order
provided
records.
them.
Oh,
I have also
order
provided
2020. What is the from 2020? What have you done? You have not paid.
Lordship during the COVID.
2% of that sales.
I'll just hand over the chart.
How much amount you have paid from April 2020?
14
Mr.
crores.
Mitro, one thing. If so, now the fact remains at the old rate from April. Let us take from April till date they have paid at the old rate 2650.
From April
2022.
From April 2022, yes.
April 2022 they have paid at the old rate.
Yes.
26,50,000 up to July 2025.
Yes.
So now, according to you, the lease deed provides for enhancement, firstly from July 2022, and next is from July 2025. So, 2 enhancement. Now, that's the only dispute.
And,
now,
no. And plus.
Pre-COVID, or sorry, not pre-COVID, during the COVID period.
Plus GST.
No, GST, Mr. Mitro, they have deposited.
No.
Lordship,
they have deducted.
Lordship, with
GST, they have to add. They have to pay to me.
Yes.
With regards to GST, I have instructions that we were depositing, we were providing the amount plus the GST amount. They never deposited the GST amount. That is,
no, I could not follow. Your check was 20 GST, as you have shown in that chart, from November 2024 is 4,77,000. It's the GST amount.
Lordship.
And rental is 26,50,000. So do you mean to say that you have paid them check of 31 lakhs and odd?
Lordship, initially it was thereafter the GST amount started adjusting.
No, that is a different thing altogether. According to you, you have paid along with the GST.
Lordship, you paid along with
the GST to them. If they have not paid, it's their liability because the authorities will catch them for not. You can also say that you have paid along because they have to provide the bills for that. It's along with GST. If they have not deposited, it's for the authorities to haul them up. Do you mean to suggest that this 4,77,000, which they have not deposited, you have stopped paying, you have deposited before the GST authorities?
Lordship, GST authorities. We are directly paying before the GST authorities.
Now, Mr. Mitro.
Ready to pay.
No, ready to pay or you are paying?
We are paying, my lord. I'm submitting.
Paying.
We are
Now,
submitting.
now Mr. Mitro,
On my account.
no,
Can't.
cannot be done. You have to pay it to them, they have to deposit.
Lordship, from what I was, there was a very recent amount. I can believe that there was a recent amount.
Only one thing. Now it's the dispute, this enhancement. Now you have terminated their lease.
I terminated long back.
So,
yes.
yes, terminated long back. Now, if this amount they are willing to pay, are you willing to regularize that lease?
No, no.
Lordship, in that case, let the suit be proceeded on trial. Lordship,
Then
let
that's the if you say yes, because that was your lease deed, because if they want to pay at that rate as per the lease deed, what's the difficulty?
I do not want to because of the conduct. Kindly look into the conduct, my lord. I have.
If they pay according to the lease
I
deed.
had on the last occasion submitted before your lordship that on the very first opportunity, they said 2% of my sale.
No.
No.
Yes, yes.
May I?
That was the reason for your terminating.
Not only that, that continued. The lordship has seen, my lord, they have started paying at the rate of 26 lakhs from 2022. April. For 2 years. Now, my lord, for 2 years, nothing was, my lord, functioning. Was I required to incur my expenses?
No, that I appreciate. If they pay.
Thereafter, I could have understood, my lord, that when, my lord, the enhanced rent, my lord, became payable in terms of the deed, they started paying the enhanced amount. That also they did not.
No.
I do not want to, my strict instruction is, my lord, I do not want to continue
with them.
বাংলায় একটা কথা আছে দুষ্টু গরুর থেকে শূন্য গোয়াল ভালো I shall proceed on that basis.
Because if you wanted that, I could have considered the in a other way.
They will not. They will not.
Lordship,
Yes, what do you say?
Lordship,
I could have understood even today, my lord, they came and said that, look here, this is the total dues we are paying.
Can you pay the total dues?
Lordship,
Are you willing to pay the total dues?
Lordship, as per my instruction, this is the amount that we are paying. As of now, we are paying month by month.
There are two things.
Lordship,
Now,
we have
you
already
entered into a lease deed. You entered into a lease deed. There was an agreement for escalation also, or
Absolutely.
enhancement by whatever.
Absolutely, Lordship.
From certain periods. So, but admittedly, you have not paid at that rate, even after recovering after the post-COVID situation. So now if you say no, even COVID, because of COVID, I cannot now pay, that cannot be accepted for now.
Lordship, I am saying that, Lordship.
Yes.
Lordship, will kindly come to
You have not shown bona fide. Mr. Mitro is right. He is saying, today if you had come saying, yes, this is the amount, yes, I am proposing to pay in this way, I am depositing or paying such amount, today balance I will be paying, he could have considered. How can he tell his client to consider? That's the difficulty on his part.
Lordship, I'll just point out, Lordship, my senior friend, Mr. See that the alleged default that was first started in April and the code started at the old rate. My lord, Lordship, that also before and she have an application. Lordship.
Will hear out this.
Yes.
If this is, my lord, the stand of the occupant,
Then
sorry.
let me proceed on merits.
Yes.
Yes. Because I was trying to find out whether it can be solved.
Yes. Kindly come to the yes. Kindly come to the order improved, my lord.
Yes.
17th February 2025.
It's in which volume?
Second volume, my lord.
There are
Certified copy.
two volumes or three volumes? Certified copy.
I presume two.
17th of February 2025. Yes. Yes.
The penultimate paragraph, the respondent engaged in the business of retailing, operating hypermarket, departmental store, non-store warehouses, distribution center, etc., used and continues to use the said demise premises for carrying on such business. Under the deed of lease, dated 31st July 2019, the respondent was liable to pay the monthly lease rent as specified in the agreement, subject to deduction of applicable income tax at source and goods and service charges.
Subject to deduction
of the income tax
and GST also.
That's valid, and GST is valid addition, not subject to deduction. Cannot be.
Yes, that is, but
it's valid.
Yes.
Somebody like me, my lord, writing, my lord, it happens.
Yes.
Now kindly turn the page. The respondent duly paid the rent due under the deed of lease up to March 2020. However, from April 2020 onwards, the respondent wrongfully failed and neglected to pay the lease rent as agreed. Moreover, the respondent attempted to unilaterally alter the terms of the lease agreement. By a letter dated 7th April 2020, the respondent wrongfully sought to propose that the lease rent be reduced to 2% of its actual revenue, that is net sales excluding GST, from 22nd March 2020, citing the global pandemic as an act of God and force majeure event. The respondent also sought to recover any overpayment made for March 2020 by adjusting it against future rates. Furthermore, the respondent requested the petitioner to issue GST invoices in accordance with this revised arrangement. The petitioner replied to the respondent's letter by an email dated 9th April 2020 denying the respondent's claim and reiterating that the respondent was obliged to pay rent as per the terms of the deed of lease. The respondent subsequently repeated its assertion in a letter dated 17th April sent by email on 18th April, which the petitioner again denied in a letter of 21st April. Despite this dispute, the respondent, in furtherance of its wrongful claim, arbitrarily deposited amounts in the petitioner's bank account which were not in accordance with the terms of the deed of lease. The petitioner returned these sums by check with under cover of letters dated such and such. The respondent's failure to pay rent from April 2020 constituted a material breach of the lease. Accordingly, the petitioner, in accordance with the terms of the deed of lease, became entitled to terminate the lease by providing notice to the respondent. By a letter dated 16 September 2020, the petitioner, through its legal representative, notified the respondent of the breach and called upon the respondent to remedy the default within 1 month. The petitioner further notified the respondent that failure to remedy the default would result in termination of the lease, with possession of the said demise premises being recovered by the defendant. Despite receiving the notice on 19 September, the respondent failed to resolve the disputes or rectify its breach. On the contrary, the respondent reiterated its wrongful claim in a letter dated 29 September 2020. As a result, the lease was terminated on 19 December 2020 and the petitioner became entitled to recover possession of the demise premises. Now kindly turn the page.
Yes.
The prayers are set out, my lord. Kindly come to that, my lord, towards the middle. The petitioner respectfully requests the court to Yes, request the court to grant summary judgment in its favor under Order 13A of the Code of Civil Procedure 1908, as the respondent has no viable defense to the claim and no real prospect of successfully defending the suit. The respondent has admitted the landlord-tenant relationship, the receipt of the termination notice, and the existence of the deed of lease. Therefore, the petitioner is entitled to a decree for a recovery of possession and the sum of rupees such and such as claimed. The petitioner submits that unless the orders sought are passed, then kindly come to the defendant's case. The defendant respondent contested the instant application by filing written objection. The contention of the defendant respondent is that the allegations set forth by the petitioner are false, frivolous, baseless, and made with malice, with the intention to prejudice the court against the said defendant. The defendant respondent submits that the contents of the petitioner's application are without merit and should be dismissed. The defendant respondent asserts that the petitioner is guilty of suppression, very, and suggestive falsity.
Those are the usual
Yes.
defenses.
Kindly
that
come to the last paragraph. Last paragraph.
Page 6, it's there.
Well, it
COVID-19 pandemic, nationwide lockdown, that is one of the
Yes.
grounds taken.
Kindly come to, yes, page 6 at the top. However, the defendant respondent submits that due to the nationwide lockdown imposed by the government of India and the government of West Bengal in response to COVID-19 pandemic, the defendant respondent was prohibited from operating the leased premises for a significant period. This constitutes a force majeure event beyond the control of any party and qualifies as an act of God. The defendant respondent further submits that the pandemic and the resulting lockdown severely impacted its ability to operate the business, resulting in financial hardship, etc. Then, my lord, kindly come to, I shall come to that. Kindly come to, my lord, page 8.
Yes.
The last paragraph.
Yes.
Subsequently, in view of the relaxation of the lockdown guidelines provided by the Government of India and the Government of West Bengal, the defendant respondent addressed an email dated 18th May 2020, attaching a letter of the same day, informing the plaintiff of a revision in the rent payable from 19th May 2020 at the rate of 5% of the net revenue on apparel and general merchandise and 3% of the net revenue of FMCG, fast moving consumer goods. It was further stated that the revenue generated through various partners of the defendant respondent through home delivery service and all institutional sale made from the store would also be including in the rent computation. Additionally, the defendant respondent communicated that if the store's revenue reached 75% to 95% of the revenue received in the same month of the previous year, the defendant respondent would disburse 75% to 95% of the pre-COVID rent accordingly. That was not done. Then, my lord, kindly, it goes on. Kindly come to the ordering portion, page 11.
Yes.
Considering the facts and circumstances of the case, the instant application under Order 13A of the Code of Civil Procedure and the written objection filed thereto, the annexed documents relied upon by both the sides, the materials on record, and the submissions of the learned advocate for the two contesting sides, it appears that an order can be passed under Order 13A of the Code of Civil Procedure when the court finds that a plaintiff has no real prospect of succeeding or their claim, or the defendant has no real prospect of successfully defending the claim. Only in such a case, there may be a summary judgment without full trial. A summary judgment may be passed essentially when there is a clear lack of merit in one party's case and no compelling reason to delay the decision. However, for such an order, the court must inter alia be satisfied that there are no significant disputed question of fact to grant a summary judgment. The instant application has been filed within the prescribed time frame, that is after service of the notice upon the respondent defendant and before framing of issues. Nevertheless, there are several questions that are required to be decided, which cannot be concluded without complete adjudication upon framing of issues. It appears that mere admission by the respondent of the landlord-tenant relationship, the receipt of the termination notice, and the existence of the deed of lease are not enough to decide the suit summarily, as it is to be ascertained whether the termination notice was valid. Now kindly see, my lord, what are to be ascertained. Number one, whether the termination notice was valid, legal or sufficient or not, and whether there is any necessity of separate termination notice after issuance of a notice upon the lessee, informing the time period within which the letter is required to make the payment of rent premium for the default period and the consequences of non-compliance of the same. It has to be adjudicated whether a composite notice regarding default as well as termination is legit or not, and this falls beyond the ambit of summary judgment. Now, my lord, the document has to be interpreted. No evidence is required. Whether the notice is sufficient or not, my lords, even if I lead, my lord, maybe 1,000 questions, the document will speak for itself. That is, my lord, the Evidence Act. The document has to, my lord, he has to interpret, or the learned judge was required to, my lord, look into the document and, my lord, come to a conclusion. For that note, in my full submission, no trial is required. It can be decided, it could have been decided then and there. The next part. Again, whether the force majeure situation absolved the defendant respondent from the liability for non-payment of the full rent is a question to be looked into. The document again will speak for itself. They have not, my lord, shown any, my lord, notification, anything which says that there would be suspension of payment of rent. There was none. All the liabilities continued. All the liabilities.
Only there was extension of time for statutory compliance.
That was, yes. That's
statutory compliances as per
that is extended.
That is extended.
Not, my lord, suspended or, my lord, not, my lord, eliminated.
Yes. So that was only with regard to statutory compliances, nothing more than that. No private obligations, no compliances with regard to private parties' obligations.
Whoever, my lord, all the other tenants, my lord, wherever they are, they were required to pay the rent.
Yes.
Then, it has to be ascertained whether the COVID pandemic could be considered to be a force majeure situation or an act of God within the scope of the lease agreement. The lease agreement, I will show you, your lordship, it says what is, my lord, act of God. Restricted to that. It appears that undoubtedly the defendant respondent cannot lounge and sit idle on the suit property without payment of rent. But simultaneously, the defendant respondent should neither be ousted from the said property without fair trial upon resolution of all probable issues at variance. It appears further that the rent issues are to be decided on the basis of the documents at this stage of trial. Conflicting, it has to be decided on the basis of documents, but at this stage of trial. And for that purpose, the defendant respondent should be permitted to rely on its bank statement during the hearing.
Bank statements is with regard to payments. Yes.
That is equal. It appears that the quantification of the monetary dues of the plaintiff petitioner on account of unpaid rent, interest thereon, adjustment if any, mean profit requires computation.
So there are two aspects in this suit.
Yes.
One is with regard to the eviction.
Yes.
Other is with regard to the area rents.
Yes.
Mean profit, which you are saying. If it is a case of termination of a lease, It has to be from the date of mean profits from the date of the termination of the lease. Mean profits can be at the market rate. Now here you are saying that at the rate
timing
for the timing during the pendency of the suit
yes,
at the rate as indicated
as
in the lease
indicated in the document.
because they cannot enjoy the property and exploit the same for commercial purpose without paying anything. But the only thing is, Mr. Mitro, is apart from the GST, these amounts from April they are paying at the old rate. There is no dispute with regard to that.
2022.
2022.
They have deposited in my
at the old rate.
At the old rate, not as per the lease deed.
Not as per the lease deed, and there is also one thing with regard to GST also.
Yes.
So GST has to be from the beginning, but admittedly they have not paid anything with regard to GST till October 2024 as per this chart, because GST you are liable to pay from the beginning also. What is this old GST which you have said recovery till financial year? What is this figure? This chart, this column?
Lordship, I'll bring that GST notification. There was a amendment or a modification to the how we pay GST. If when I am paying rent, I have to pay GST on that. But if the GST amount is not being deposited by them to the government authority, then I have the right to deposit it directly. There is something along those lines. I'll bring the notification tomorrow, my lord. I'll bring the notification tomorrow.
And you have documents to show that you are paying GST directly to the authorities.
I have documents to show, my lord. I have documents to show.
Nothing was disclosed before the court, Miller. Nothing was disclosed.
And
I have annexed everything.
There are two things.
No, it's not on record before the court.
Even if you pay, because liability you have to pay to them, and it's their obligation to deposit it before the authorities. So does the notification also take care of that situation, that if you deposit, there will not be no liability on their part? This absolves them of their liability.
Lordship, when I was also
authorities haul them up, what they will do?
Even I was also of the view that they have to pay the GST. I have to pay it to them. They have to pay it to
Yes.
They have to pay to the authority. And
even if I accept that you can pay, a notification allows you to pay. But for that period, if you have to show the documents to them so that they can also take the benefit of that. Because if the authorities proceed, now look, it's a disputed question. You are saying, I am paying, they are not depositing, for which you are directly paying. They are saying, no, I am not defaulting. Since you have not paid, I could not have deposited. But if you deposit it directly, they must get the benefit of that deposit. Otherwise, the authorities will proceed against them. So it's nothing, even if you pay, so they will be liable. That cannot happen. That cannot happen. Yes. Mr. Mit, anything more?
No, I have to show the document.
Yes.
Kindly give me half an hour's time, if possible. Tomorrow, my lord, I can come back and my lord conclude.
Tomorrow?
Any day. Any day.
Kalke ki ache? Think every day 4 p.m. is fixed. Entire way.
Any day. I know.
Now, if it is after 7-10 days,
I forget.
Not you do not forget, Mr. Mitchell.
No, I can appreciate, my lord, your lordship. It's not possible, humanly possible to remember. So many matters are being heard. I was, my lord, surprised to my lord when your lordship said that he has occupation charges. Nothing paid.
No. শুক্রবার 4 p.m. তো আবার 3:30
Definitely. I know, my lord, yes, all of us know.
Can you start from 3:15 and continue after 3:30?
My lord, I shall be very candid, my lord, I don't do it. I say that, my lord, as long as I am a member of, my lord, any association, and, my lord, the association takes, not for any other reason, but because of this. It has happened, my lord, as secretary of Bird Library, I opposed, my lord, a resolution to close the library to the utter disliking of many. But, my lord, when a decision
Only
is taken,
difficulty is that this hearing matters, it takes time. That is why I'm keeping it in the later half.
can we come at 3? At least, my lord,
On Friday.
any day. Friday, I am saying 3 because, my lord, we know for certain that it would be 3:30.
ফ্রাইডে ৩টের সময় কিছু ফ্রাইডেতে কি আছে? এই ফ্রাইডেতে কি ডিভিশন বেঞ্চ আছে নাকি? নেই। ফ্রাইডে
Oh.
pursuant to the Let me for 10-15 minutes, Mr. Mitra, if, because I'm trying to take some urgent matters. That is why. Yes, ma'am.
One matter was fixed at 3 p.m., my lord. Can it be fixed tomorrow at the
3
top
p.m.
of the
was
list?
called on, these matters were taken up.
My lord, no, my lord. That was in the daily list 235 serial
Daily
item
list.
number. Yes.
They have taken combined list. Let me see when I can
Your
take it.
lordship. Deeply obliged.